Amen, Tashina, Mena, Au, Eno, Emi, Bashe, Bilkukra, Nihe, Lefe, Bilkukra, Nihe, Lefe, Bebashe, Baba, Bele, Beami, Nihe, Lefe, Banae.
Shout out to you, Nala Vishida. Into Ito Yote, boy, Ojogba.
Kani mi heke lo mi heke lo eko. Kani mi heke lo eko. Ame tashina mena. Eno kemi bashe kekwe. Kani mi heke lo eko. Kani mi heke lo eko. Amen, Tashina, Mena, Au, Edo, Kemi, Bashe, Kikuri. Bilkukra, Nihe, Lefe, Bilkukra, Nihe, Lefe, Bebashe, Yukoba, Bele, Behami, Nihe, Lefe, Banae. Bilkukra, Nihe, Lefe, Bilkukra, Nihe, Lefe, Bebashe, Yukoba, Bele, Behami, Nihe, Lefe, Banae. Bilkukra, Nihe, Lefe, Bilkukra, Nihe, Lefe, Bebashe, Yukoba, Bele, Behami, Nihe, Lefe, Banae. Sadembae, Sademba, Sadekomba. Sadembae, Sademba, Sadekoluchemwe. Sadembae, Sademba, Sadekomba. Sadembae, Sademba.
C'est mon fait, mon yote, minda mon fait, mon chi. Wabekon, mene wabachuni, wabekon for God and country. Shout out to you, class captain. Toyota, offering inchuni, hey. About a couple of hours, feel than about reflect on class captain. Oh, well, I don't know why I didn't do my job. If maybe I didn't know that ninja show she. How about che, Miniano? Theoke, Miniano, Mawati, Toyota, Jude Nelson, Toyota, Robert Atto, Toyota. Shout outs to you, Atago. Shout outs to you, Dave Eason, Inyemi Toyota. Shout outs to you, Maryland. Shout outs to you, Thunder and Lightning. Wabekon. On no press conferences are here. Sempe bi aba fe press conference. Ngleshi Alata bi aba fe press conference. Mini poten jinoni judgment here dey ncheke. Shout outs to you, Man Victoria, Toyota. Shout out to you, Mabna. Mabna boy, your jogban. Mini potage no ni judgment take. Wabakane judgment take humble. Kawabena. Waka secretary to Nii Danso. Wakalebaba and wakalebagba esane. Next week when Wama Sempe an opportunity. Now I'm about responding. And Nishikuji near the south of the Oblogo road there. Mini Cortec and no more pote no me. And it's Sempe anoni. Allo Danso we kue ni yo Ngleshi Alata mi allo ama menoni. When we John Kobri Sunday ni achole tunga when we misagono na kenjemegbe ani shikpoji eko ya damami sakamami ena achole freedom and it down so we kue ame yeni komo ye kome wabakwa no ni ko tu eke ntumobeni nkebu eke di wagbe no ni ko tu eke atan wake Nii Danso secretary ni Oblogo wake baba bano. Next week we will have Sempe an opportunity. Kake Oblogo Mills family and na me protege Oblogo Mills family ni mine wa we kokomene ame yeshikpon baba o na kain. Shout outs to you Ma Yifo Ayite. Shout outs to you Clarissa Papo. Haba Kemo mokonyo kemo kwa ke waba twashie ko Boma de no ami continue ni ya mweko Boma de no ani love emoji sa flow Ko ba shebia no kemo mi yalo ye chat section e onu Shout outs to you, Robert Wifey. Robert, Inyaminu Robert, Fatalo, Man Victoria. Man Victoria, Mlenche Inyaminu Robert, wife. Mlenche Inyaminu Robert, wife, Man Victoria. Imatoya te boyo jogba. Our wife, Man Victoria. Ajay. Our wife, you are taking very good care of my brother. Thank you so much, Man Victoria. Johnny Femo no kemo kwake wabatashi for God and country. We are here again. Oliaga ke bagandang be sanjiele ekokula be feni tete TV. Kemo fe mo yue atan. Eke wo be ko miniji no ni wolu eke. Na kanjibo ni wachun ole ye bi miniji no ni wolu eke. Miniji no ni ko tu eke. Heba. Like I said, Ochine miye wake Nii Danso secretary. Eba we Ngleshi Alata waka me ba jeshishi. Next week, we must Sempe one opportunity to make their case. Mini e no ni judgment take. I mean, call me alone. I mean, call me. Mini work judgment take. No kotan. I mean, here me alone. I me. Because can try me press conference. Abu Abana can ni enfe to mo be no ni judgment take. You I make a back be too much. Mini wa make no ni judgment take. You back be too much here. Next week, we have an opportunity. Now, maybe you. Heba. Kemoko. Heba. Nyebo amode. Shemo. Johnny Femo, Onu. Mama they no like it show. Nyebo amode class captain Kenya no go. Haba. Shout outs to you, man Grace. Toyota ima. Oh, back and then Sunday much trouble, ma. In Oeche. Heba. Haba.
Oh,
Brahma they no like it show. Johnny Femo. Can on Facebook page. Can me jame. Oh Instagram. Oh Twitter. Hey baba. Ngena can be a sheno, na can be a sheno, you will back belly bear very soon. Begbele money can dang be sure. Fe baba mi. Ni gamba chake. Gamba ko mama papa nebu. Johnny Femo. Be o like issue e gonti no ni ya wen bomodin. Johnny Femo, Chemoko, no Chemoko. You like ya show, and you like ya show. Helba! Shout outs to you, college, Miniano. Shout outs to you, Eric Nate, Miniano. Kemoko nio kemoko kemoko nio kemoko. Waba trashi. Be na woma yin afua akpa bona. Get biane wo platform ne. We cover press conferences pe ni wo ba shin ke page me. Minute no ni wolu eke. Ona boni ni eyo. Nke those days are gone. Wo ba kan de wolu wo fe what dey school. Je lawyer fo eji wo mo. She brofo ekome ke wo kan e wo nu wo shishi. So wo ba kan ni. Where the kake wo jame no ni wonu shishi wabani ayagbla mi yan wo. Haba! Shout outs to you, man Rosina, Toyota. Shout outs to you, Maggie. Ichikome. Maggie boy ojogba. Maggie mi abo kisses. Hey. Heba. Shout outs to you, man V. Heba. There you go. Thank you. Minda mo fe moshi. Like I said, bomodeni ojani fe mo. Ona boni ni yo ja. Neke biami ni eshe. Wa ni mo kwa uwafua. Wokpa. Ke wolo ye ekome to ele. Oba kwano ni wolu eke. Bona. So team A ba nye yue no na ameli. Team B ba nye yue no na ameli. Ke ame fe ame yue atan. Eke wo ba ke wolu eni kando na ame yu no. Mineji no ni wolu eke. Nuchu mo na ke wo ba chun la agbene. Ona boni ni eyo. Mene potenji no ni wolu eke. Now, when we shipon ni judgment ba ke south of the Oblogo road. When you go to mo Jonkobli, ni achole tunga ekotumo emisa gono na kanjeme egbe dama sakamangbe Nii Danso ni Ngleshi Alata jame ni bi kome kolomo ejeme na me potenji ablo mills family name ni ame ye shikpon blala ne ke ame kome to nge ka ke ma pe chonbwe na me shikpon cover je no go bibio e. Now recently na take court ya na kan shikpon jie na apele Sempe manye machombo egbe ken kande ni habwe le Nii Danso ne dumo Ngleshi Danso ma manche eke wonche ko meni fita me ma chombo meni fita here ameke sandene te court meni me defend oji Sempe manye ke ni akamaje eduma akamaje najian amenkwe ni bi ekome wenyele consolidate mina chola kola cha ruling ba no na kola cha ruling feji e flush pon fe shani mokono aje mokonomi alo mokono ya je mokonomi no ni judgment na efe aji egbla ni bi ekoma mini after kola cha judgment ni bi ekoma efe a little cloudy shiponchi ekoma efe a little cloudy judgment ne any na kan cloudiness yo quote non quote ona if you make judgment ne ekpe unu fio eswe any na kan cloudiness yo after the akolache judgment ona boni ni yo akolache judgment eja no fe no eke ko ba unu ba she call na gamashi ko fo call na street no boy kolebu emi ya agbene benu agbene obote alata bia no mi Sempe no yemi kama aje no yemi Ngleshi denche uno yemi agbene be na ajale enwe efio make moko usu ka moko show moko eni moko no gbe ona ye moko no jioshi eje shi be pi eni efe tu moko no mbote moko no mi ona ni eni ha no ko yin efe no ko yin ni it's been a lingering issue for a very long time judgment ni clarify no ko fio hawo now Sempe bi enchono gwake judgment ne 14.2 acres sanepe ani na kan lele jino ni judgment ke alo judgment boni ayuele a cover ekoni edafe 14.2 acres pe. You understand what I'm saying? And neke issue ne very very important. Nka look wa bagbele no fe no na ehabo esani wo fe wo na going forward there keji wo ba ko gamba ko mama papa ne ebue esani wo ka no kwale atuni esani wo ke mla atuni esake wodi enche wo ko mla awo wodi nke that has always been my beef. I don't care money your manche, I don't care money neke inogo club mo be eko Simon etowo amalie etowo mingbla mo etowo. We need to change GAN and make it better for the future generation. I don't want chata kebo seko ni tete TV ni chata ba e tabi olo no ni ntune chata be ba tuwe ko dabi sanike chata fe interview e ke businessman in fe interview e lo me ken yagana ya mamoni bi jeni apele shikpo shikpo jin chin projects be chin projects ana chino ya ke shole mwana. We cannot keep doing this to ourselves. Esanike she chata anye ne ke sanjiamiolo dabi sanike batabi chocho ni bi ne ke shole mo ke no ya babaga je aba. That is why we are doing this. Ke ba she chata ma na ken se ba fo sani wo bo anu kwale ayeli ke batabi ani cheme ni nye wo yan me ya anu kwale ame male no wo ne to wo lo no wo generation e to wo. We need to change that. Ona boni ni yo so noni ma feji matwa Sempe bi a press conference say ehabo Koni set the ball rolling kehawo. Now, ke intranuatan in your 40 judgment 49 pages, I believe. Wakane efe dabi. Wabakane shishije. Koni onna what the case is about. Okay, what skip all the way to like the 20-something page. Jameji any the meat of the matter start off from. Okay, what can the no eta? Makane quickly, ma about 20 pages. Give or take 30 minutes time. I should finish reading. Ke bena eke wake Nii Ablo eba bano Nii Ablo legis secretary to Nii Danso ma manche eba kewo no ni le nu ohihie judgment no mien kane ya bomo no mi obo Sempe no ni Sempe bia unke eke bode nchona. Now me work nka ata omoko na ma ha mi shi ni the shako no week ne me mabomode. I am sure ake ameba kwa ne ke interview ne so manamoko ni eba you me moko no ma omo alo akemia ke moko no ma ya available keji minta oni ma use mo shi masumoni inke moni video ni ma twama habo ne bona masumoni inke le agbasande so le enamaji moni noni inke atawo amie ye Sempe ni amie pale ni ma twa a video ma habo le ji moni na ma inke atawo ami shi by Wednesday ken ni share no mabomode koni mahani moni no ma available le koni akele ehami ni nkele agbasani ke wo ha mehu an opportunity keji amefi ame yake ame ba sumoni ame yue keji ame fe kwa ame yaka ame ba sumoni ame gbasani ame ka wa gbasani ele no ele ma no le no na ke je ni woni what take one side against the other ona sanjin ko me sani wa na agbene ka me ba hu wo ba do mo judgment no ke wo ke bia me sani so sempe bia e ba nu ne ni judgment na eje ko mi ni jino ni portain ni sempe bia we judgment e ani ame ke judgment en pagbe allow to some extent I make a judgment pagbe ni mini mingbla mo ameke ba ni mingbla mo na ameke ba na kanjiboni court to eke allow je na kanjiboni court to eke ke wo kan de wo ba nu fe now nye ani wakwa sempe biye no ni amewe after the judgment came out. Let's go. Bomade no like issue e come fit away no like ku e bomade ko no like ami gonti bona no ni ya nwe love emoji say le nwe nya no nya love emoji say no. Shout outs to you Raymond Toyote, shout outs to you Auntie Amelie
no ji current judgment ne ni neka judgment ne ejenshi afi nyuma ne danso wekuwe ameji meni take court no atwa me plenty
o fine watchene ni wi one leni mintawo ni inkele agbasane e so inke atawe no ma ami so far ni de sheko no o fine keji o kwami ni ole watchene min kpabu fai bobo de ni oke enama ascend mi e channel allo ke video ascend le no ke like masumo ake ni tete TV wokele agbasane so watchene le normal interwar like I said afe moko normal available e hami she ake ni le ewie e wo masumo ko ni inkele agbasane on behalf of Sempe biye so ye shiba mi mo fe mo ni ole watchene ni yo ni oye nama o fine ke enoma ami ke osumo nwe obanye ni oke na ma le no kala ga ni tete TV ke e ba sumo na ya opportunity e koni amena jemu alo ameshishi no moni yo ne ke judgment e here ameke ba nya wo bo ale to
ameke sempe no bien sempe manye na ko me na hekweti amekla ni te court moni je nyono na amekla teji magrata be ke ni ayi candidate ni ji akoma je manche ni kenkle court na te ne e ko shiponko ni edale 14.08 acres pe heku ame wemoji na ke shipon ne ame chanini e woyam na me wotole estate of Oshimashi wo hu woke o na ka shipon e fata he ni woto papopora ame sangon no he wo Sempe wo no akoma je bia nke o amecho waje me opete papo chiji ama me no ni mla akwe etemi ne kwe le na ke o lele sans effet lo 14.08 e agbe alata no ni be amina me kwa me wale ke jio alata no mi ke lela ke alata ke ha me be Sempe be no ko le ba yu e ja ke je Sempe no ni efe fine ha wo na ke shipon ni nchon e kan papopora ye jama no ma yu ke shi o John Kobli ke surrounding area se fe amame no won wo ke dabi dama wo no se kama wo no no he wo jaje te la kishi John Kobli papopora ami sangon no ke ama country shipon alata no dama ke sakama Sempe no efele fan ake heni acho John Kobli ne ami sangon no papopora ke ama country e dama ke sakamante ete no yu ake shi o Alata shipon na chene. Etake hekonu wacho Oblogo road there. Etake Oblogo road there. You actually I'm shipon the south of the Oblogo road. Ni you actually Oblogo road there. E north Sakamayo ojebe. Ne tere yo wakashio. John Tobli neni nyete mpinye lakishio tunga ike dama ni sure wusu. Mpwase woyo ne head water mpwase. Dama yon shiye wo wase egbe no. Ike dama ni sure wusu. Now, neke charge ne. Lord neke judgment ne. Kojo lo etoke je judgment ko ni kan bi omo nu otole. Mako concession inquiry. Neke judgment ne. Aha 1960. Ni a judgment ni ko shipo ni ka eni wato moto dama sakama mpwase ma bibia fe ne bole kete an kate botiano no pege judgment ni ka shike de blema ka gbe ngene high court judgment idu mo boss maleye na a report le 1961 Ghana law report ka shimene ne ka judgment ne ifite kuwe akokwa achekwa vonko do no jino ni kashi ni no pe ni judgment e ton shipon ni yo moto ni neka moto na egbeji Sakumo lands ano mako lands ko chele Sakumo we o ba chele mako ni no pe judgment ni yeke me fe oko na mo ko ke yin 1990 judgment ko yin judgment ko ni ko ni je Sakumo je concession inquiry ne ukara judgment ne hiye e call moto heko kaji 1960 na judgment ne now judgment ne na ba ha abashipon ko to lo bashipon no ke me na ba kwani bi ni yo no lele me na me ma yo shipon no na ke mpose ni gisempe ma hemi wota ne e ya moto mi oduba e no chamo dama mi gisempe shipon le ya moto mi oduba e no chamo John Kobli alias Bogobri alotunga le ya moto mi oduba ko jeje me be o ya papopora moto bi papopora e gono ji amisa gono ama kwantre kamisa gono ama ye hekobi na me jo me ji papopora ko jeje me sport kashie fake ya sakamani now actually like manji na fe Sakumo lands ida ke am fe me Sakumo we aha judgment okay dama Sempe noni John Kobli ke non meni ncho omuwe Alata noni Sakama huwe Sempe noni mena bi ni wona ochi ne ake meba wo dama jo mi ame wo ma egbeyi ame ke mi pete na kanon Sakama jo mi ate jeme afi na kan mi gbena lo mi nimla ha me na kan gbena ma fe ma gbe fe ni che fe ko ye jo mi ke mo be ke na ka ma be jo mi a chele Sakumo land chame fe these are Sakumo villages around the bank of the river no hewo 1959 be ko ni abada na ka na judgment ni Sakumo ulom e ke Jamestown ko ke Jamestown we be o che me eten wo to le Trinity o che Sempe o cha kumaji no cha Alata o fatahi o wa che Sempe kenkele ja Alata be na me ba wo to am heko it is on record e wo nyo cha Alata ba no wa che Sempe kenkele no mi che Sempe e balakshi ayesani na ke wo shipon Jamestown shipon wo che ni jini Sempe e wo no ba shu wo no no che me ye e wo sana gbulami na omo ke ono ni yomi na temi ake o wono ni yomi ekoji eni wota ni mpwase wono eko ni yomi jidama wono eko ni yomi jisakama John Kobli jeme Hausa settlement chi Alata manche ni hube ko ni huwe leji mo nke je ha me wa me Alata senji kagmene what in court lo ma yan se fiu no hewo a compensation ye na kashipon na kan noni wo fe wo na ke pambro so te Elmina sought winning company who. Aha compensation ye no. Ni judge na kesho Sempe di bi ye me wo. Aha Sempe shikiago. Aha about 30%. Na ke alata no ni yo me da fi wo no. Ake ya krowa ni yo se egbe tetogbu aplaku ke botiano amedra wa ewo eba no da fi wo no eba 50%. Ewo kan mene what e kwata ma no kesho no na ye be ko de ho e. Le fi say you no here. Tell fi o ten Bomona have 14.08 acres. Ya papa rapons. Segba ton. O ba damaston. O ha dama jomi ngolu. Aka je mfe nyenye no. Me judgment habo neke hegbe. Judgment ake papa pora ke di ake hanye. Ake ha alata e je danso wekuwe. Ake ha alata. Na ke dama ke sakama ake ha Sempe. O me no ba dama jomi. O ba dama jobi wa ko dama shipon. No ya sakama jobi na ko shipon. Bi amene judgment ne motor judgment na kan chole motor mi judgment ne kana ka ya judgment na afo mi mako concession kwa afo mi wona ka kisho motor mi na ka sane na yi bi ko ni wa aftele ni mla ha na kan egbe e jake time no pa appeal ke bi me fen ho ina yira ni afo won teme ko mepo e wo won wi akishime na mete wo stone wota shi don ni mla ha wo higbe mla ke wale ha wo ameshi wo stone no ame ha wo na kana wo we na ke woka ya ni mla ke woka ya wo hu wo ya ageme ya ke wala ke je wo no ni won ya wo yin no ni you ne akola judgment of 1963 high court judgment e you if you je chon shi 1960 no ni tani chi ne no ji no ni blood Kenya wo yin wo ye stone ba wo Sempe we stone ba wo joni inyanu echi ekumata je fen yes o shebe ko ba shebe je inyanu egbele kumami lo echi ekumata ha wo na gba ko we ko di le kashi ni Sempe wo ye wo shipon no no your freedom Sempe Manche village but no you are okay Sempe Manche village uni akọ oka ya ko you na kan alata e Sempe Manche village ma tonye no jibotiano wo ka wo you no ujin ye wo you no ko wole nche wo nili alata no ji Sempe Manche botiano ji alata Sempe Manche village wo no ji bi ene e wo ka nye sabja se ba ko wo no ni to wo fi
Awano.
Sempe Manche village. Sempe Manche village. Ablogo's family. I've been registered me. Nimete la tabi okoshi lands. I've been registered me. Freedom Chimo, I'm a register. No no you one. No you one. Kaje blema. Ke back 1990 judgments neighbor 1990 Supreme Court. Na te ahun mo ko challenge ko wodan. Na keje me fen hawo. E wo me ni gba no chon. O ka register lo ka call je me. Mlai me bo je me chon me ni quarter land. E wo ko ba wa ke me ni quarter no. Quarter de no, ke na quarter bi bo je. No ni ekole, nke ekole ona hegbe no na ni ye je me. Je me chon Sempe quarter land. Ewo Sempe Manche ke hechie pe. Ye mlagbe na amena manya me mbogbe. Lo ame habo. To heko ye geme. E chakeko. Ayesane 1948. Ajeshi 48 agbe na 1963. Loji akwarashi judgment ni nyen nuwe chi tombo. Ake gem fen wo no. Gem fen wo no. Now, naka judgment what the judgment of numbers. No me akanyo. Kabani akwabi ene o Sempe mete. Alata nyokomi e ka obebi ene Sempe no. Kati yake o alata me 20 yo bi Sempe 15 ka keje halata. Yake ni mbawa. Ni woye mlako na kan yega. Si akoti ma case kuna kan I establish na kan mla. Wona kan ga kote se na kan. Kote se ke na mishpon. Jemetron Sempe quarter land. And we are Ludia owners. Come go to Aludia owner. Onyo kala akoti don wako eni. Because I declare as an Aludia owner. Kejeblema. E wonyo fite na kamla. Leko fite lebe sani be sani na ye kejeblema fe fite. Hena Nii Alata. Hena Nii Sempe. Akia Sempe this are quarter lands. Wono mini. E wo mimi nye fio ejeme. Ha onye register ni shipo da wa. Shipo ni wo US ani e da wa denje. Ni Sempe weku ye jemu duba. Me ni Sempe ke shipo ha me Sempe grantees. Baba wo ye jebe. Ni shinu wotane. Be fe be agba me na. Atula wo ye bi ene. Ha wo le nche wo lumoni yo jeme denje. Aketutu wa mi. Wo se no talo. Ashibento ofio. Ya bindo. Le hu na gba ko ba ni na ale. Maba. Ablamus weku ameje Sempe. Be am no je Sempe bi mo fa mo ni ha mo shpon ejebe. Be na kan grant it is invalid or defective. Be wale kokura be mi. Yake jeme ake wo no ni. Judgments ke wo no. Yake jeble ma Sempe weku yo jeme. Duko chakeko. Oya na gba isort ye he ko. Comment fio to mon fils na gba ejeme sani ye court Sempe ko tu blohum o yu ejeme chon wo ye ma baba o oduma se Sempe ma wulu ni na kan ma bibi ba o ya nshi e Sempe gba mi anya ablekuma olebu ni ya wulu bi an alo lobu Sakina Osuima ni okopon ebie ananabu ise Osuma mankralu ke se kwelo lene wo mo baba o yo to aple o ya kwashikuma o ya kwashima o ya kwashibu o ya obom sotum obaya new term bibiami. Hey baba o. Hey baba o, how ba take wo Ghana na no ya Togo. Wo ye jebe. Wo ye jeme Dubai. Wo ke wo international. Nje mpo ne che wo mo jon Dubai. Te fiote wo no local e bi ene. Ake wo shila shi ye. Na kan be eho. Kaje wo no wo pele hi. Shika wo no ni. Mo fe mo no te no. Ba he wo di. Eni bi sha. Eko dama esaka shipon la tebe koshi ni mete freedom Sempe manche village yeshia woni nya hawo won weku yeshia woni nya hawo dama job ye dama ni sakama job ye sakama ni mete Sempe shipon ni freedom la tebe koshi wononi ni mete Sempe noni yeshia woni nya hawo no shi watane litigation must come to an end. Eja ke sanjin ayi omo. There you are done.
So there you have it. Like I said, Sempe be a response to the judgment. G noni inke intra ehabone tomoboni onu yeni emi obana keshi. Shout out to you, Auntie Maggie. Shout out to you, Man Christy. Obana ke ameche na kanje megbe fe. Now mine woni ameche na kanje megbe nke buake. Now akolache rule ne. Akolache in your judgment at some point makane any justice akolache. E bla mi ne ke meneno jiene shitemobeni nke buwe mogo sure unsu any moko boundary bi ona ye moko no jio shishi ejeme ni ona ke be bi ke bale na kan ni e bote o mi ke bote ni emi. But I think this judgment ne e feel clear ni clearly keji obo Sempe repair to feel because I feel like this did not go on a boni yo boni amelele poten boni amelele ojogbang. So I don't know what would be the next step for them, but what I can now minute you no need judgment take chameka nyeme what can Nii Ablo baba no koni ka yue no koe koni onye ona enone ke no appreciate Lord but no koni onye no contextualize noni watche eyu but once again me pabo fa keji ole watche obanyo ke na ma hale alo ke na ma hami media nche matwale min tawo a number nka tawo am she fi ma ge ni sheko no olo aka mi ake moko ya available she means money nke la you because legi money you shout out to Felix now nyani what kind of judgment there for you shout out to you na mi sa na to your thing koni wakwe shout out to you fan hub koni wakwe mini potent judgment take judgment le ewe ni bi ai e touch on ni bi kome on aboni ncho oba na ke clearly no ni watch ewe ke no ni judgment take ameka there is a little bit of a headbutt between no ni judgment ewe ke no ni watch ewe like I said I would love to give him that opportunity koni e ke back more supporting documents I feel like e ba kononi e ba support no na ewu ajogba ke no na ewoni eke ti actually ten judgment na pa agbe so ani what can de keke onu shushu ajogba nke ni ele ne ke jiboni wo ba yale kan ani moko lakabo understand what I'm saying sani enemese afu ni ke enemese ba afu sani wo bon le ne ke ya wo ba kwa no ni judgment ke what say kwa moko ba tabi na ewu no we ko na now like him show ja nyoke moko isani o blantai ni yo sempe shishi na mesumo sempe amen no ni judgment take shishi sani o blantai ni yo ngleshi sana amen no ni judgment take shishi na amen na esa ni waka wo no sani waka mla atuni no waka dia ke sanete court ni court ke ne ken you may not like it gamanche sanene ke agbena next week no ni court ba ke wo fe waka ba atuni we cannot keep on with this forever we cannot. No fear, no ni court back here. We cannot keep doing this forever. At some point, it must come to an end. You understand what I'm saying? You may not like it. Maybe ever young or favor. Maybe over like it the way not small. But like I said, we cannot keep doing this forever. You understand what I'm saying? You cannot claim ake osumo gan no osumo dangbe. Ni at some point you don't want litigations to be over. One thing you at some point litigations must come to an end. I agree with him. I agree. You understand what I'm saying? So no fair no ni ya no at some point there it's a nika court to a year when you work at chuni. Like I said, you may not like it, but when you watch your man so on forever, now she will. No court to a decide na ke ne ka ya le. You may not like it, but no mommy, no move ahead, no move forward. So now, nya what about your judgment tell me? Ni wa kwa ke miniji no ni judgment tell ke and no ni watch you na kan pepe jinoni judgment kelu so nyani waboti ameke in the Superior Court of Judicature in the High Court of Justice held on Tuesday the 15th day of April 2025 His Lordship Kenneth Edem Kujoji J sealed number FAL/111/2015 so obanake this case it's been going on as far back as 2015. Producers, me be my eyes because me kind of from a different screen. So kaji noko yejeme na sanima na inang. So me kanify nyani malia va wa page no. Kenoko yejeme ni isanima lie koni mana. Nyani waboti. Like I said, it's 49 pages. I'm not going to read all the 49 pages that I be in fail na kai. Shimo noni waba afeji. Nyami one second. Makwa keke ngbelele ne ken still nyeba na lu kenye na mweke wokwe let's see. Nyam one second. Mingbele with a different program. Ni makwa ke still ken gbele nyeba na kemin kanelu. Yeah, fana I'm 1 second. Onu. Mingbele yeah, different nine. Ma zoom le out. Nyami 1 second. Minta oni miwe fe easy am ye be so the bigger the better. So yeah, me 1 second. Ming bele with another program ni makwake no ba feel easy e hamilu. So no ni ma feji. Makande shishije keke boni jaje capture sane wana. Eke must skip all the way maya somewhere around the 20 something page. Bona. Eke jeme any wabako keje. Eke jaje ke ming bla mon femba. Eke chonwo boni le na sane ke noni eke bayemi. You understand what I'm saying? Now, mind you, nye Ngleshi Alata biye. I know I'm a press conference. Ni ameka rebat noni Sempe me fe. But because one na rep from Ngleshi Alata iwo intrando ehambu because one na mokode ba yue on their behalf. Ona boni ni yo no ene so noni wa ba feji noni ka one na mokoni wa kale ba yue keje Sempe ma je next week bona keke watcha nakaino wo habu keke wakwe jeme you find it yeah me 1 second. I don't know why this is doing this. Yeah me 1 second. Ning panye fire wa denche. Baba no okay. Okay. All right. Can me scroll it down from here. Nyonya ba analu. Yeah, 1 second. Dabi nyana. So do this. Anima share from this very screen. Keke walkway. Here we go. Nyana. That's good. All right. So like I said, producers, you find it. You pay attention. You hear me. Cause in nani yo ina njomobano. Thomas Tete, shout outs to you, Samuel Tete. Let's go. Nyani mafia. You find it be here be. Me zoom here, on my zoom le be me boyo. No go baby any my zoom. You find it you bear with me. I think this is clear enough. Okay, yeah, thank you. Yeah, so nyani wayano. Wajianshi. So, like I said, no, you know, na meji plaintiff say, na meji me ni kesanieti, Dan Willie Danso, Nana Kwame Danso, Alexander Danso, all 15 Chokome Street, all Dansoman suing for themselves and as administrators of the estate of Emmanuel Kofi Danso, aka Nii Danso the first. Niji Danso ma manche niji kenkle if you make mene me fe obaka ke ebi jiame as administrators of a estate ameni ameke sanieti. Number 4 ni yo mi number the fourth plaintiff is Nii Danso ni jienyo leji Danso ma manche biane actually Mordi ni aku Danso leun eje first 15th Chokome Street o Danso man name amekete na meji defendants ni yoson sanenemi na akushika umadru niji ete aka Janet Adukwe Aloti substituted by Ningmai Ado Sempe manye echon ese ni woni moko substitute on a behalf. Second defender ni yonoji Margaret Abbey Dansoman High Street Dansoman Accra. Number third defender ni ayikan ni jiete leji akamaji manche. Now judgment, okay, judgment. So it is not a ruling, it is a judgment. Now, the plaintiffs then instituted the present action per amended writ of summons, a statement of claim 20th February 2019 for the following reliefs. So I make a sanenete, I'm institute a substituted action, and I'm a check, I'm a read original read. I believe I got original read was the one in 2015. I'm a read in 2019. Menejinoni I'm a tower. Ake jaje afe ehane. A declaration that the land described in paragraph 9 herein forms part of the land granted by the Jamestown II to C.A. Danso, which C.A. Danso in turn conveyed to his son, Nii Danso the first, deceased, also known as Emmanuel Kofi Danso, deceased. So, kawashe paragraph 9, wabana shiponjie na chon, ake Jamestown as a stool, ameni amekaneke shipone ha, C.A. Danso, ni C.A. Danso wuni before ne ba jemie, lewu ekan ebi niji Nii Danso niji kenkle ni lewu echon ese. An order for the recovery of possession of portions of the land described in paragraph 9 of the statement of claim hereto from the defendants and their purported grantees. Ake court order. Bonia fe ne keshe konji ne na titan paragraph 9 ne keme ne your defendants ne ji sempe manya ne chonse ni mo substitute hale akama je mancheke Margaret Abe komeni amenyenye jeje order koni na kan na amenye aka me no ni aye na kan jeme fe ya amedi mind you ona kan kebo akashiko eni mokono bi ona ye mokono starter she ke okwe akola che judgment ewo no confio. It was very clear she mon ni efe to mo bole dum fio ko so I mean seek an order koni afe ni clear ka afe le clear koni eni mokono mokono ebote mokono mi na afe fa ya me susu mo mi ne defendant na list I mean bote komami no judge an order koni na me bote ne sa na me bote yo aye na kan jeme ya me de an order for the demolition of structures unlawfully erected on land forming part of the estate of the plaintiff's late father, family, or stew. Akekeji me emamo shine. Alors emamo ni bi ye neke shikonji ne ni ete ameno mi jeje order koni nakaino akumofe ashwi nakanji noni amensike number D. Or letter D, excuse me. Get number D. Letter D. An order of perpetual injunction to restrain the defendants, agents, servants, workmen, privies, and assigns from entering upon, disposing of, granting, or dealing in any manner whatsoever with the land described in the schedule hereto. Koni a perpetual injunction continuously. Age perpetual benyele ni twaga na agbe akabai. Stop mo femo. Ne ba fe yake e ba bote ne ke shikonji ne ni judge e ba kake kama mo etun ye no po akumo. Ona boni ncho judge a stop mo femo ni mogomogo akaba ne ke shikonji na mindon. General damages for trespass. Akani amebote eko ni esa na me ya anwe. Judge afon shika afon ameno. Koni amepe eke cost. Now, the first defendant filed a statement of defense on 3rd July 2019 and counterclaimed as follows. Sempe Manye 2019 a declaration that the land in dispute does not form part of the estate of the plaintiff's father or the Jamestown Alata stew. I can get she continue na yele susumo mi kele boni ele ke boni le cheme kele na keno ya Jamestown Alata bia no mi agbene we noni wacha danso niji sempe niji danso mamanche kele no mi dabi ne ke she continue ya le enomi. A declaration that the land in dispute forms part of Dama, Bakopora, and Amisagono, and therefore Sempe's two lands. I can make shipojine if it a Dama shipoi, if it a Bakopora shipoi, if it a Misagono shipoi, Nika Acheneke manjine, Aliake Sempe bia majini, no keshipon jinkome yajame, ni if it a neke majiano here, be esani akoake Jamestown Alatabiano, and for that matter, Nii Danso niji can claim, le nomi. An order for recovery of possession. Ake ameu anamebe. Koni ameu kanibi kume ba jeje order kona ame recover na kan ni bi efe ni eba amedin. Shout out to you, Blessing David. Yep. Nyawa ya mi no ni wachano. An order for perpetual injunction restraining the plaintiffs, the second and third defendants, their successors in title, principal, servants, agents, assigns, privies, and all those claiming under or through the plaintiffs, second and third defendants from entering any portion of the land and or entering with the first defendants' enjoyments of the land. An order for the demolition of any unlawful and unauthorized structure on the land, cost, including legal fees. Now, I'm a mention of Wake, KJGF, ne enaka me sane yamie. Ameu JJ astopu mofe monie jamenomi. Kebote ake ebaya na kenshikono. Agbene we keji ama monibi komeye no. JJ ame wale boni afe ni bi na mamu no fe. Ame kumo fe ashwe. JJ ame be boni afe ni lawyer. shika keni bi court to shika na ame fefe ame ye meni ke sanene badi. The second and first defender niji Margaret Abbey ke akamaje manche niji ni amakan niji eten edabi nge ni amakan ni ayi kan niji eten lewu ame defense na ameke bani. Again, the second and third defendants filed their statement of defense on 27 January 2015. Initially, the defendants were represented by one counsel. However, he later withdrew his services in respect of the second defendant, who remained passive throughout the proceedings. At the end of the pleadings, the following were adopted by the court as triable issues. So, at 27 January 2015, Margaret Abbey, Kenya yi kan ni jete ni legia kama je manche no me lawyer kome Jimoni amenye Shimon neke lawyer ne engme Margaret Abbey eja ke boni ni bi kome yale esumo ye na agbe mi ni bi ni amepene ake ameun no ba form part of amenagie money. Whether or not the land in dispute originally belonged to the Jamestown Alata stool, ake anishikpo ne na apeli oye anikejo buade no me Jamestown bi ano lo b. Whether or not the land in dispute was the subject matter of conveyance dated 30th January 1951 from C.A. Danso to Emmanuel Kofi Danso. Ake anishikpo ne na apeli oye ne efita shikpo ni C.A. Danso eke ha ebi niji Emmanuel Kofi Danso as far back as 30th January 1951. Lo. C. Whether or not the defendants have title documents to the disputed land, and many amebane ake amen defend the case in ani ameya wolo ni chonke ne keshipoji name ameno lo. D. Whether or not the second defendant is carrying construction work on the disputed land, ake ani Margaret Abbey niji leji second defendant ani ebo enuchumo yeshikpo no lo. E. Whether or not the disputed land forms part of Opete Pakpo lands, Opete Pakpo lands, Jamejie ni akuma ajebiye, alwa kama ajebiye, ame claimo ake amameno. So bana ke no fita no ni third defender niji wachenia ni ayika ni jete akama ajemante bi ake jeje afele clear ake anineke shikpo jine na apeli oye ameno niji Opete Pakpo lands anino we fita yelo. F. Whether or not the disputed lands belongs to Akamaje stool. Ani shikojine na apeli oye. Ani Akamaje biye amamenolo chata yangwe. G. Whether registration of the disputed land by Danso family is valid or not. Ani shikojine ni Danso wekue amete ni ame ya register. Ani ejini nkpakpa lo ni esani adomolono ake akabachuni alo akechuni. Now, nyawakwa minishikoji ayu onye buatu agbeni. Again, the land subject matter of dispute belongs to the Jamestown Alata stool. Sanji ni Danso ni jienyo ke obakola ke nyeme ameketene. Granted a parcel of land, including the land in dispute, to C.A. Danso be ameni and others by the then stool occupant Nii Kofi Akrashi ni jienyo. Ni chwakebe Nii Kofi Akrashi ni jienyo ne be Ngleshi Alata manche ni because Nii Kofi Akrashi ni ji kenklen leji Ngleshi Alata manche kenklen. C.A. Danso by a deed of conveyance dated 30th January 1951 also granted a portion of the land to his son Emmanuel Kofi Danso, also known as Nii Kojo Danso the first. Ake 30th January 1951 neke shikmoji ne C.A. Danso ekia ebinu ni achole Emmanuel Kofi Danso. Nii Kojo Danso the first remained in possession of the demised land and exercised acts of ownership of the land by granting leases to prospective purchasers and members of his family. Le wache Nii Kojo Danso ni ji kenklen le grantoma mancheni at the time. Le uneke shikmoji ne eka kome ha ewekume ni ne sumuake eba ho ni me aye ni amekefe ni ehonwen. According to plaintiffs, defendants have indiscriminately encroached and disposed of his lands. The actions of the defendants, especially the second defendant, is found on a claim that the land was acquired from the third defendant. Ake ne wa Margaret Abbey ne shikpo ye akamaje manchedi ni chono kwa ke ne ke shikpo ne akamaje manche hole ni ke ame Nii Danso bi ame kwa ne ke shikpo jine ame na ke me babai mi ni ame nkolo shikpo ni ame nishi eha me. According to plaintiff, each land was adjudged by various courts to belong to the Jamestown stool. And recently, there was a judgment in respect of compensation for the acquisition of Dansoma land by the government of Ghana is to be paid to Nii Danso. Okay, court to Ibaba o eyu ake neke chiko jinele ame Danso wekue ama ameno ni government po pay compensation ke ha ameni alo ameche niji Nii Danso niji kenklen. Now, case of the first defendant. It is the case of the first defendant that she is not occupying any portion of the Jamestown Alata stool land and that she is on the Dama and Bakpo Pora lands. First defendant Sempe manye at the time chono kwake shikonji enile eko alole yono alole ehoyami alo ekehame na keno eye Dama ke Bakpo Pora no mi ni Dama ke Bakpo Pora no mi Ngleshi Sempe biano je Ngleshi biano no anye akelake be eko neke shikpoji neko. The land subject matter of the dispute does not form part of the Akamaje lands known as Opete Kpakpo lands, rather Sempe lands. Ake keji ni ayika ni jete neji Akamaje manche kake neke shikpoji ne lewu eye no miye je na kani. Mind you, ni Akamaje lewu shikpo ke has second defender neji Margaret Abi. Bona so Sempe manye at the time and file and we get dabi le ni Akamaje ne o shikpo mpo eha neke wamami Margaret Abene leuna kan shikpo jele no so Sempe manye nchono kwake shikpo ne yo miye je Alata bia no ni je Akamaje un bia no shimon dama ke eneche Sempe bia no efita opete Kpakpo noi ni abaka ke Akamaje bia no. The said Opete Kpakpo lands were adjudged by the Privy Council in 1912 to belong to the Akamaje stool. The said judgment was followed by that of Nii Amanokwe, the second versus Nii Ayikai McLean, the second in suit number 46 of 1985. Amo amenchono kwake neke shikpone 1912 to be akake by the Privy Council etwake Opete Kpakpo lands pe jinoni Akamaje biano so ke aye damma ke Kpakpo poro sane esa ni Akamaje bi ba na me ba ko akejeme amame no ni. According to the first defendant, she is on the land in dispute through the permission of Sempe stool who has remained in effective and absolute control of the land. Niti was Sempe manyene echono ga shikpone no because Sempe biano ni Sempe manyeni ni ke jobu ade na ke ne ke shikpone Sempe biano me jino ni wache ni ayikan Lileji third defendant. According to the third defendant, the disposal of the said land is within their rights as they do not need the consent of Jamestown stool, who is not the owner of the Opete Kpakpo lands. Amame nchono gwake neko Opete Kpakpo lands ne ama Akamaje biye amame nomi na me need moko permission, especially Jamestown stool keji ameba fe no kwe. The ownership of the Opete Kpakpo lands resides in the Akamaje stool and it has been affirmed in various judgments in respect of the said lands. Ama menchono kwake Opete Kpakpo shikpo jine court to ibaba o echoake neke shikpo ne amenoni ni Jamestown Alata no. So onake inyabo noni mo fe mo ke noni first defendant ke noni second defendant ke noni third defendant ke meni ke sani unte noni ameke ne nkebwake akola che judgment ejani bi ami femo but because any moko no gbe ona ye moko no botium yewo it makes it a little cloudy no keneket sanjine ba what this judgment sought to do jake na can cloudiness and sound on ebani fa fe clear. That is what this judgment sought to do, and if you ask me, I think it did just that. Now it can issue say mahabu because any trouble case so nyani maya any judge a boy sania eta kokwe mi aye capacity aye issues aye ni BP. She like I said ka waka won kanefe wona ko wagbina wakase ni nkeje church appeals court judgment any gamanche sania fe wo so nyani waya any ejon she get your root of title that would be about the 20 something page keke egblani BME awowa na mo yo ewale lele tuneke land say akola che judgment mini poten ke and efe ni bi ni esane efe and egblam yojugba. So page number 20, let us actually start from there. Now ke min kane ni nake ekobe all that too important maski pijame bona keke inte. Shout outs to you, Nicholas Nii Okankoyayi. Shout outs to you, Frankie Kembi. Shout outs to you, Evelyn Ablo. Shout outs to you, Alkaline Niji Ete Minimum Family. Shout outs to you, FAW. Te Oyote. Inke Esani what you know what no don't what apply way. Esani wani mla atuni. No what sometimes in show ne it is not all that entertaining for young people, because young people are sumo gidi dabi. So no what check again for the better. And that is why I like doing this show this way. We need to change our mindset. We need to have a renewal of minds. So ni Tete TV is the best platform for you. Nyani wachano. As stated earlier, to prove a declaration of title to land, a party must prove his or a root of title. In what constitutes title, the court in J.K. Aka versus Francis Egan 2014, JELR 67146CA said, title is known to be means by which a person establishes his right to land. A person's title indicates the means he claims to be the owner of land. Title to land may take the form of possession, or it may take the form of documents or a series of documents. I think this does not need any translation. It is pretty clear. So, good title is derived from A, an enactment. That is what an enactment is. Your title to this nekenoko. A grant, vesting order or conveyance from the state. One more grant is vesting order. To Moboni, what you see Danso fake, ebi Emmanuel Kofi Danso is a conveyance. It can hale one washishi. A vest, a lot of vest into a family, into a stool. A final judgment of a court of competent jurisdiction. Ake court to ba kwesande. Ne ba ye ne ba ka kesande ne ni ye lele mene meji meni me own title to the land there. A grant, an acquisition under customary law, conveyance, assignment, or mortgage, which is at least 30 years old and establishes that the person is entitled to convey an interest in the land. A grant, allow an acquisition, based on Nibia document no check it na habo title it becomes yours. Allow through a mortgage. No here at least for a period there you own that land as long as the mortgage is in existence. Boshiponi. Allow once again a conveyance. Paragraph C of subsection 1 does not apply where there are conflicting judgments of courts of coordinating jurisdiction in respect of the same subject matter. Akeke court to strote eha decisions come ni amika me intwa number 1 anye akeno atuni. Now, from the pleadings of the plaintiffs, the land in dispute is part of the Jonkobil lands, which was adjudged to belong to the Jamestown stool. Indeed, plaintiffs are claiming 14.08 acres of the land situated at Dansoma, Jankobi, Amisagono, and 14 acres of land situated at Dansoma, Jonkobli. It is the claim, so on a judge specify plaintiffs niji what chemeni amekenekeno konete I mean claim 14.8 acres of the land ni eye Dansoma Jonkobli Amisagonomi. Agbeno another 14 acres of land situated at Dansoma Jonkobli. It is the claim of the third defendant the land in dispute is not part of Jonkobli lands, and that the disputed land are part of Opetekpako lands which have been adjudged to belong to Akamaji land. It is also the contention of the first defendant that land in dispute are portions of Dama, Bakpopora, and Amisakono. Into parenthesis, Achekwe, first defendant, Sempe Maniaka, Dabi, Nekeshipone, Dabi, Dama, Bakpopora, ne Amisagono, Nuele Sempe Mepe, Ameno, Amekemuko Eja. Now, contrary to the claim of the first defendant, that the fourth plaintiff has not positively identified his land The description of the land in paragraph 9 of the pleading stated that satisfy the identification of land. Achono gwake first defendant na just Sempe manye. Keji ka ke meni ke sanene ba amechoko poten ni yo shikon mi na me bio isane jeje ke dabi ke okwa me pleading say me am specify poten na me chon ke nakai no ama me no mi. In his witness statement he said, in fact, plaintiff's land share boundaries with state housing estate and state housing estate shares boundaries with Akuko Photo farm land. If anything, it is the first defendant who has not identified the land granted to her by the Sempe stool. Le Sempe manye ni leji first defendant bele mo kra jimoni echoko eni shikon yoshimo meni mekesani eba ame chon eni amenoya. Defendant is a counter-claimant and therefore has the same obligation as fourth claimant to identify the land she claimed as hers. She has not even described her land, in contrast to fourth plaintiff who has done so. It is portion of the land described in paragraph 9 . It is portion of the land described in paragraph 9 of the statement of claim, which plaintiff claimed has been trespassed upon by the defendants. The first defendant, the fourth defendant, Nii Danso ni jienyo, legis Danso ma manchebiane. Jaja kedabi le muele echo any poten yuake amameno shimo Sempe manyele echoko any ake amameno no ekelekmagbe. The protagonist to this suit claiming ownership of the disputed land through judgments and from the provisions of section 64(1)(d) of the Land Act 2020. Any of such judgments constituted good title if it is declared in one's favor. However, there is a caveat, which is that if there are conflicting judgments in respect of the same land, then none of the conflicting judgment can constitute good title. Ekanomo ake keji mokonye court to documenti. Ni court to document and kake enele nomi mokonye no nene kele nomi. There are conflicting judgments. No ele anya consider neke judgments enyonefe as a good title to any of them. But no ele boli no jinoni ebani neke case no aba. Boni afeka mokonye ni mokonye na sa tamie kon na kwake between amiyenyo na mo potenji money neke shikone isani akake le enoni. I must add that the conflicting judgments must be from a court of coordinate jurisdiction. This is because a lower court judgment, which is contrary to the judgment of a superior court in respect of the same land, cannot be a good title, as it will be subservient to that of the superior court. This is self-explanatory. Kaji oteeko ni court to bibioko abo judgment no nyena ken judgment here na appeal alo akete court to agbo. Ni court to agbo enwe onyo ka ke bomoni onye court to bibi judgment na favor abebo no dabi echumla chuni na ke court to agbo ni le we tasane no ni court to agbo ba ke e ba overshadow no ni court to bibi na kanjiboni mla chuni. Above notwithstanding, none of the parties to the suit pleaded res judicata. Rather, they relied on the judgments as proof of possession and ownership of the disputed lands. Ake ene me fening bla kake res judicata ni chwanke aye sanye ne asheko na hia wo mi ne sa na tai don Supreme Court allo ete privy council the privy council ye agbena privy council ye London chuchu enagan ka ye awu ni agbena ebi na ke privy council ni privy council ye ekobe no kwa ya don no kan case res judicata isa na tai don amenchono gwake menyo ne ni kasane ne ba fene ameteme ko claim res judicata aka o sanene na ye na aka privy council no ni privy council kene no ewo esani asa ata sanene no don na ka jino ni res judicata simply emino if I'm a lawyer say babo further and better particulars, but from a layman's point of view I can get res judicata na kan nakan sane ete eko na agbene esa na tai do anya ye do it becomes settled law for lack of a better description. It becomes settled law pe onyo tai do nakan. Now, the following cross-examination was pregnant. Now, what kind of cross-examination ni judge call? Now, why I know? Many you know ni judge cross-examination if it pregnant. Now, a big question: is it not the case that the disputed land constitutes Jankobli and its surrounding lands and settlements, which is now called Dansoman? Answer: yes. I wish I could judge in a money across examine le. No. See, okay. Judge make reference to any cross examination. Piniana versus Afram 1966 Ghana Law Review 2020 Jameji any neke cross examination neje. So abisan yake. Is it not the case that the disputed land constitutes Jankobli and its surrounding lands and settlements, which is now called Dansoman? Answer: yes, but we have exhibited two judgments on the same land in court. One is Marco Salt Inquiry 1120. That judgment was delivered in 1960. Obanake nekeno wache ni ewe on behalf of Sempe. It make reference to neke Marco Salt Inquiry ne. It make judgment. Now, fourth plaintiff laid claim to the land in dispute on the basis of a conveyance on the said land to his father by the Jamestown Stool in 1951. He could not provide evidence of the said conveyance, which he claimed was lost in a fire outbreak. Nichwake fourth defendant niji wache Nii Danso ma manche bia ne. Echono wa yeneke conveyance ne. Niji wolo nichwake be eni. Keneke shikpone ha ma alo yeneke papa I don't know. Yeah. Amebe wo na kan wolo 1951 ni Ngleshi Alata dabi. Ni Kofi Akrashi ni jenyo 1951 eke ha me niye. Na kan wolo la chanle. No, amebe na kan wolo ejeje eke le eke wolo ko ba ni eke ba chon ake na kan. He therefore relied on a search and statutory declaration as a proof of the said transaction. Shimon a face search benye liake lands commission nke buake lands commission no friend no eje ojo twa ko beje julo eni oja ma me no ame awo gbla awo ni bi ami lands commission no friend no eje no komeni blofo me kenke ame no man no friend no na me lay down no friend no ale shikpon kokla be ni ale moni no old map ko ni ne she ko no kenke chombo obana boni yo nine di enche ake draw ona boni gamashi yo nka ake ni ne draw nine map gamashi map na ake ni ne draw na afa chujin na afa street self ene yo ekoklo abe now so wachane ni neke conveyance in 1951 esha he rely on the search the statutory declaration ni sending as proof. Now the search revealed the existence of a conveyance from Charles Danso, Leji C. Bonyana, C.A. Danso, to Emmanuel Danso and others dated 30th January 1951. In any conveyance, she search reveal like a lele eni. If I'm mistaken, and you be back blame. Lele ake eni keneke no ne a papa. Ona bonicho search produce like. It also indicated that there was a grant 18 February 1954 from Nii Kofi Akrashi to C.A. Danso, Lenoji Charles Danso and others. In 18 February 1954, Nii Kofi Akrashi ni jenyo, ni Ngleshi Alata mante at the time, a grant in a keshukonjine, kea wache Charles Danso ke me conclude. From the search, there was also indication that Emmanuel Kofi Danso exercised ownership of the land in dispute by the existence of grants to other properties. Okay, yes, search no prove ake. Kofi Emmanuel Kofi Danso niji wache Kofi wache Nii Danso nebe papa leji Kofi Danso niji kenkle wache Kofi Danso leji Danso ma manche niji kenkle wache Nii Danso niji enyo nebe papa waji uye ni chwake leno ekaneke shikpoji no hame kome ona boni ni yo so search provide ake as far back as 1951 but Danso we ku amena amenye ne keshiko jine ni amechuni ye. On the statutory declaration, they are considered self-serving documents, which is incapable of transferring any interest in land and therefore are not probative value. In this regard, the statutory declaration of the plaintiff is of no probative value and cannot be evidence of any transfer of interest to C.S. Danso and others. See Agbosu versus Kote, 2003 to 2005. First, number 1 Ghana Law Review 685. On statutory declaration, they are considered self-serving documents. Okay, and no go ni body enchebe o fe no ken o ya lo no go no echo age lele na transfer no go ke ba o mo go gba mi alo no go. They are not probative. They have no probative value. Na kan juno ni judge e ke ona body ni yo. Now, since fourth plaintiff title is a derivative title. Can't get derivative title. No to transfer of ownership. That is what a derivative title means. Title no based on transfer from one party to the other. It puts the title of his grantor in issue. It puts it a little bit in issue. In the same vein, the third defendant is also claiming the title on behalf of the Akamajes too. So in this regard, we must determine which of the stools owned the land in dispute to determine whether the respective grants are valid. No, yes. Fourth defendant, Nii Danso ma manche biane. E ka Akamaje manche. Amefa mempeleni so asani wa kwake neke no kone namo poten. Esani wa. First defendant, who is also claiming the land on behalf of the Sempe stool, is in the same position. And the first defendant energy Sempe manye. Leu e claim yake neke shikmo na mameno. So shikmo echo me eteno. Mind you, no wako teke. Keji me yete ni mo femo ye. Judgment shorty. Bona ne claim title to a piece of land there. Naka no fesa ana ke chuni. And unfortunately for all three parties, moko claiming res judicata. Moko gesane koba ni chwake aye ena aye agbena ne sa ni moko ba ne ba bio isande don alo ekeri chos ani ese ekodon ona nakajino ni jeje. So many jino ni jeje ba consider jeje. I will first consider the decision in the Marco South Concession Inquiry dated 22nd June 1961 under Adumwa Bosman J. This case involved opposition by Sakumo Wulomo to the grant of validity of the concession of the ground that is the owner of the lands. Once again, neke mako concession Sakuma Wulomo ke neke shiko jine fe le nomi because obana ke ko sheje me gbefe bo na ke Sakuma ye jeme. So he claim the subject matter of the concession lease and not the Jamestown Manche, the grantor. Now, the court found, as established in the case of Manche, D.P. Hammond case, the occupation of the following towns by Oshertown people: Chokome, Fajiemoye, Wejoshi, Shiayena, Clay, Manfiomli, Wiaboman, Akweteman, Impuase, and Griffith. Akaneke court find ye neke MP Amon case yake neke towns nefe Oshertown benyele kake Oshertown we be oye many me form of Oshertown ji asren abola bese ke na mo ekonje asren abola bese ke na mo ekonji benyele Oshertown be a 4 ke Jamestown be a 3 I mean if you're 7 born so kake Oshertown be ameni now the question the court was left to determine is the ownership of the following villages. Shimo neke manche amon case ne court to a chon ake neke towns ne Oshertown bi ano Fajiemoye, Chokome, we Joshi Shiaye na Clay Manfiemli Wiaboma Akwetema impen wasem de mamponse impen wasem engrefe Shimon court chon ake Botiano, Aplaku, Tetegu, Sakama, Jonkobri, Damma, Impuase, Bebeise, Shona, and Grefe. No, ne kote chon meni nomi. Naka eko to neke MP Manche DP Amon case ne. Aka no chon ake koshe na kanje megbe neke towns ne le Oshertown bi ano. Shiko ba Botiano, Aplaku, Tetegu, Sakama, Jonkobri, Damma, Impuase, Bebeise, Shona, and Grefe. Le kote chon moninomi. In order to establish owner of the concession, the Sakumo Wolomo must have evidence of occupation of the above named villages by persons who owe allegiance to him along the mouth of the Sakumo River and Sea. This will give him exclusive ownership of the whole land. Damma and Sakaman was admitted by Sakumo Wolomo as Sempe villages, whilst the court in Marco sought concession inquiry upon evidence concluded that Tetegu belonged to Aplaku. Sakumo Wolomo ne case ne no yo dasiake Damma nke Sakama no ele Sempe biano shimo ye Marco cost concession Marco sought concession evidence chono kwake Tetegu le Aplaku bie ano. This then paid to the plaintiff's claim in the present action that before the breach, Tetegu belonged to his family or the Alatas too. No, based on any choake, but Tetegu shikono it belonged to the Alata stew. With regards to Jonkobli, the court accepted the evidence of the grantor, Jamestown stew, together with that of Ilo Jonkobli, Imoru Galadima Yaya Musa, which established Jonkobli as a recognized Jamestown village. Indeed, in the Marco concession case, Jonkobli was described as Hausa settlement, and there was also evidence a prominent surveyor, Mr. Amar Quantren, built a house in Jonkobli area. Impoase was held to belong to Sempe, whilst Begbeise and Begbeishona was concluded to be Jamestown villages. So once again, Marco concession no ekblano phenomenon. Impoase Sempe biano she Begbeise ke Begbeishona le Jamestown village ni. Underlying all the foundings of the court is the age-old principle in Ponoglu vs. Kadaja that evidence of occupation must be to the extent of establishing exclusive possession to merit a declaration of title to the land concerned. A consideration of this principle tilted the ownership of Sakumo lands in favor of the Jamestown people. So based on any war, naken Sakumo shukpo GNE or jeme, akenya Jamestown be. Now, in the Marco concession case, the name Dansoman never featured dito. The chona ke Marco concession case ne be aka Dansoma a feature in onale pote tumoboni ono imbeno na gangma Dansoma ngwebia onale na kai. In the case of Yaudwade Crab, Nii Amano Akwe II versus Nii Ayikai McLean, the implication being Dansoman is a latter-day name, probably after the estates were built by the government of Ghana. Ake semi-mon, then in the case Dansoman bene ebajepo. It therefore does not feature as one of the three stools or quarters named in the Yaudwade Crab's case as forming the Jamestown Manche Paramountcy. Because the case is never na che, I can be a mere a beko na chole Dansoma iwo na kan jame fe abulake Jamestown Manche noni. The third defendant, in support of his case, tendered that decision of the Nii Amano Akwe II and Nii Ayikai McLean as the case which declared Akamaje stool as owners of Opete Pakpo lands. Ake niji Nii Ayikai niji etene provide neke case ne ake no chon ake shikpo jiye no ni yo Opete Pakpo no miye na kenjeme ame nomi. In the above case reported as Nii Amano Akwe II versus Nii Ayikai McLean, the court noted that Opete Pakpo lands were adjudged to belong to Akumajes too, but the extent of Opete Pakpo lands was never declared in the court of appeal. Ni chwage leleng neke wolone ni wache Nii Akamaje keba ayu ake Opete Pakpo shikonjinye amame no mimo shi acho ene ya wa acho edale ke ene ya ta na kanjino ni akadeke sanene te court of appeal. However, in the present suit, the question to be determined is whether the land in dispute forms part of Opete Pakpo land. So once again, ke ye neke sanene miye eba kwake neke shikone na appeal oye ani if ita noni wachole Opete Pakpo shikonjinye. It is obvious from the admission of the first defendant that the disputed land constituted Jonkobli and its surrounding lands and settlements now called Dansoma. Okay, kejeji akwa ni efe ye sisumomie ye fan ake neke shikpon ne ni sempe manye yuo ye eji shikpon ni eyo jonkobli no mi ke settlements ke eni me ebahi ni bia ne achole danso ma na kanjino ni judge ke. The fourth plaintiff is claiming the dispute, is claiming the lands in dispute as his personal land, which was demised to his grandfather by the Jamestown stool. Ake fourth defender niji Nii Danso man bi ane Danso man manche e kake neke shikone le eni neke ha ame no le no mi. Being a derivative title, the title of his grantor is put into issue, and that is the reason the issue has become a battle of stools. In similar vein, the third and first defendants' claim to the disputed land is based on both Akamaji and Sempe stools' claim to the land. From the evidence, the issue of determination in this court is whether the land in dispute, what we are chagbene, Jonkobli, Amisagono, Pakopora, is part of Opetek Pakpo land or Jonkobli lands, and if it is, which two, be it Alata or Akamaji or Sempe, is the owner of the disputed lands. So Jajeke, based on the Yemonefe, Shikpo na chole Jonkobli, Shikpo na chole Amisagono, Shikpo na chole Pakopora, ani eye Opetek Pakpo Shikpo mi, alo Jonkobli Shikpo mi pe eyo, Nikeji nakainie, namo poten eni nakan shikpon neke shikpon ne le no mi ani Alata no alo Akamaje no alo Sempe no nya wakan ya bi odugba. From the evidence, the issue, so jeke noni about determine based on nibi na KLFG ani shikpon ne achole Jonkobli Amisagono alo Pakopora ani neke shikpon etene ani efita Opetek Pakpo shikpon alo efita shikpon na chole Jonkobli pay no nikena kan ani neke shikpon ne ani Alata bi ano Akamaje bi ano alo Sempe bi ano. Thank you. Asan Abola Bese Otubloun. I'm a former Oshatanwe. Oyulado. Shout out to you, Laye the first. That's right. Royal Majesty. Yetwashi. That's right. Yeah, wakwa one ya no biane. Like I said, anything future generations, be bakwe. Wani ala kamukodo ni echaki. Jele mi echaki. And we must make sure. Any no if you on a waseko, ni nyecho 90 years. Beka ko baba ne be bakani. So I am happy doing some of these things. It told me coming can but I love it and I enjoy it because in Liake we need to do some of these things. What's a go type yeah, I am, about popular app. Now will now, first defendant in his written address noted that the parties to the suit have tendered various judgments in support of their respective cases, and the issue arising from this is which of these judgments support the rival contentions of the parties. In his view, the determination of the above issue will also resolve the issue of whether the alleged grant made by Jamestown Alata stool to C.A. Danso and others, which C.A. Danso also purported to have conveyed to Emmanuel Kofi Danso and others, is valid. If indeed there was any such grant, I could not agree more. First defendant, a written statement there, because mo fe mo nyenye wo jinka ni bi ne mene kene neke case ne ka ye e ba tun potin money shikoni nike Jamestown Alata bi a shikoni e ba prove ake lelen Jamestown Alata manche at the time ni Kofi Akrashi ni jenyo lele ake ekeneke shikoni wache Charles Dansolo ni leun eke ha ebi na chole Emmanuel Kofi Danso keme komelo nike na kanie ani na kano abanye akano achuni lo njaje ke pepe oyue sanene keji nkwamie lele ebani wakwa ke ani lele ake bleko ne we akashikpo ne Ngleshi Alata bi anolo ni kelela ameno ani lela ke Ngleshi Alata manche at the time ni Kofi Akrashi ni enyo ekashikpo ha watch Charles Danso lo ni lewe ke bi ni Emmanuel Kofi Danso lo Danso manche ni kenklen lo jeje jenshi. Again, I will start my evaluation by reference holding 2 in Nii Amano Akwe II versus Nii Ayikai McLean Supra. Because anytime no back can judgment na ke Supra onanchele gami. Ni chwa no go na mention omo in kaniabu ake Nii Amano Akwe ni jenyo ke Nii Ayikai McLean no judgment ni Nii Ayikai ni ete ni akamaje manche no rely on ne kake based on ne judgment ne na kan shipon efita opete pakonoi aloje na kan chele na kan cho land tekemi ni no ewo akamaje biya no. Now, the customary law was that even though stools might settle on the land, it was the particular stool family, tribe, or individual who had reduced any portion of the land into its possession that had the authority to exercise rights over it and to defend it. Okay, weku alo stool konomo she mokomeni yomi lile ebanye ejie ni echono kwake. Yes, I belong to this family. She ne kometo ele even on ye weku name ya alone ye neke stool name ye mino na kaino abangmegbe ni ko teke le yo e wale ne ba defend yake lele ene le no mi ona boni ni yo. This is the customary law position that informed the judgment of Akolache J in the case of Nii Danso Crab Stool, Stool of Jamestown versus J.A. Kwe, Stool of Sempe, and in Nii Danso Crab Stool, Stool of Jamestown versus J.Y. Boy, Stool of Sempe, and Godfrey Robertson Adiko versus Emmanuel Joe Akufo consolidated, reported in the law reports as Jamestown Stool, and another versus Sempe Stool, and another 1989 to 1990. Second Ghana Law Review 393. Jeje nwe nye buatu agbene. Jeje nwe bi na important. Jeje abo nwe mu agbene. So nya wo bu ale to ojugba. Kani mokolakabo. It is worth noting that this suit is about land ownership in Gamashi. In other words, the people of Accra. So it is imperative that before I continue my analysis, it is apt to reproduce the all-important pronouncement relating to land law of the people of Accra by Griffiths C.J. Intete Kwaku versus Paco Brown, Divisional Court, 21st February 1910, and quoted by the Supreme Court in Jamestown Stool and another versus Sempe Stool and another as follows. At the present day, the land on the other side of Kole Lagoon is dotted with farms belonging to the Jamestown people. So nkebake Kole no jami koshe Kolebu Junction ena chole Kolebu Junction jame separator Usher Town ke Jamestown thing. The other side belongs to Usher Town and the other side belongs to Jamestown. Now kake Jamestown benyele 3/4 na ka chon Ngleshi Alata Sempe Akamaji ona boni chon amena ameji Jamestown quarter ni Usher Town quarter ji gbese asan kemini Oblogo kemini ko na in draw blank here be the whistle my be no asan abola gbese Oblogo bona ni shout outs to you ma oti shout outs to you Shatta Drake bona so akiono kwa ke ko so mo film no le na ka area mi I feel clear. The other side, cause a Kolebu Junction, before Babo te Kolebu and me, na can Junction me no ja Jamestown, ke Usher Town thing. Usher Town, Asan, Oblogo, Abola, ke Bese, Ameji Usher Town, ni Jamestown, Sempe, Ngleshi Alata, ke Oblogo, neke, enyone, ka me back together, ke Ghana 7 quarters of Gamashi, bona. So, Kolebu Junction, no ja me, no separator. Now, Jeje repeat the same thing. Most of the farms appearing to belong to Alatas. No doubt, many have been made quite lately, but some of the Alatas have not only farmed on the land on the other side of Kole for years, but with the consent of the Alata Manche, have built houses thereon, and they have not been in any way disturbed. So I'm quoting again from as far back as 1989 to 1990 case. Until comparatively recently, all the land around and about Accra and the other towns was wasteland. People dare not live outside towns in unprotected villages, as they would have been in greater danger of capture by marauding natives. Questions of ownership of land were probably never raised unless some European wanted a piece of land whereon to build a fort or factory. And as the forts and factories were also built close to some town, there could have been rarely any question as to whom such land belonged. In the early days, I doubt whether the Assyrians would have claimed any land, except that was not quite close to their quarters. There was no need to claim any land. It was all common property. Where there is so much doubt, so much uncertainty, so much indefiniteness, and where land has until recently been practically of no value, all that the courts can do, what they ought to do, is to accept accomplished facts, and whether may have been the state of things 200 years ago. I am satisfied that it has been now for many years recognized that Jamestown collectively owns the land on the other side of Kole. Emphasis mine. Because na kake Kolebu Junction na kan shikpo na chomochi road there no ke je dogon show na nko ba shaka na kan no ja Jamestown ke Osha town mi mo fe mo enu shishi na kan ni ke batabi ane na kan no moko eje ko wandi sandeko bako no jeje ke le e ba kole na kan le e kole na kan, because as far as ni is concerned there sandeko bako na kan fact. In effect, Gamashi proper is separated by the Kole Lagoon, and the other side of the Kole Lagoon, stretching from Kole Gono onwards, like the leaves of a tree, was populated by the Jamestown people. No need UFA, no JJUE. From the above consolidated case, it was noted that the Jamestown stool has 3 quarters, namely Alata, Sempe, and Akumaji, with the occupant of the Alata stool being the occupant of the Jamestown stool for historical reasons. It was established in the above case that Kolegono, Kolebu, Choko Nyebuatwe, once again, in a quotife from Ubanagano Chofe, Akolache, a Befe, Nyebuatwe. This is very, very good. I love reading some of this. It was established in the above case that Kolegono, Kolebu, Choko, Odoko, Sabon Zongo, and Dansoman have been lumped together and given a broad name as Latebiokoshi. The said Latebiokoshi lands is Jamestown's 2 lands. However, the question posed in the above consolidated suit is which of the 3 quarters own Latebiokoshi lands. So onaka nakan jamefe acho jamefe Latebiokoshi lands. No one in a case neighbor. Ni egbla mi fe akola check bla mi fe chomo ni no egbla mi fe bona. So no. Just as the above mentioned consolidated suit started as suit between Crab family and the subjects of Sempe in a native court and later transitioned into a battle between Sempe and Alata stool, the present case which is between the family of Emmanuel Kofi Danso, Sempe Manye, and Akamaje Manche, has transfigured into a battle between a subject of Alata stool, Manche of Sempe, and Akamaji. Asa akuse eko no koneni nkebwake akola cheke say there was another judgment koponi nkane umpo ni clearly judge ekopo kele pangbi, and that is where ni eni wabajene. Now, to determine the question of which quarter is the owner of the land aforementioned, various judgments have been tendered with respect to various settlements in Accra by the protagonists to the present suit. Notwithstanding the existence of various judgments to support their evidence, I get the impression that the parties to this suit lack knowledge of the above pronouncements of Griffiths CJ, which remain the most definitive pronouncements on Galans in Gamashi. Their knowledge of the judgments they have tendered, judging by the evidence at the trial, suggests that either they lack proper appreciation of the judgments or they are not being truthful. Ole, ke in the judges, ni they are plain ke engona wai. Ke in the judges, ni they are very plain in their judgments ke engona wa. Baby, Justice Ban appeals court judgment. He was very plain. A sugar coat inoko. Ka male lojibu Justice Ban really plain. Eke sikli pa ya ke bo male. I like it. Judge fe ne ga ke me tene ni ke sani e ba fe. Ke kwa sani e me na ke ne ke Griffith CJ case ne. Either amele ni amenu shishi. Alo ame ye anukwale. In other words, ame male. Ona no le judge ba kwe ni mofemo ni male ni ekesani agme eni ekegme. Now, from the Yaudwade Crabs case, 3 cases, namely Manche Anege Akwe, Manche Anege Akwe, Sempe Mancheni, versus Manche Kojo Abebio, where Ngleshi Alata Manche, Tete Kwaku versus Papo Brown, and Hammond versus Abebio stood out. And from these cases, the courts fashioned out occupation and exclusive possession as distinct from historical narrative, which is often inconsistent and unreliable to determine ownership of land among the Ga people. I hate Kamuguke Gans, particularly Gamashi. We are Ga people. We are not Gans. We are Ga people, of the people of Ga. For some reason, anytime you man and Bana. In the words of the court, these 3 cases decided that ownership of land outside Ushertown and Jamestown is to be determined not by alleged historical title, by proof that the land was in the use and occupation of the subjects of the quarter. I can make a case in any I establish Keji or go outside of Shikon near your Gamashi proper, ke Jamestown proper. Neke towns ne fe Shikon Jekedi akwesa na call by title pe. She asana kwe money useful. Ke money poteni echunoko ye na kan Shikon use and occupation of the subjects. No, about determine which quarter actually owns that land. In this regard, the undisputed history of Galands was summed up by Griffiths J in Kwaku vs. Brown is as follows. Again, now, again, the Assyrians were the first occupiers of Accra. Therefore, they were originally recognized as the owners of all the land round about Accra. Then the Sempes and Akamajis separated themselves from the Assyrians, amongst whom they had come to live and located themselves on the other side of Korle Lagoon. Therefore, they were recognized as the owners of certain lands on the other side of the Korle, which used up to that time be regarded as Assyrian land. This plaintiff admits. Then the Sempes recrossed the lagoon and took up their quarters between the Assyrians and Korle Lagoon. Therefore, they were recognized to be the owners of the contiguous land, which had up to the time belonged to Assyrian. This plaintiff admits. Then the Alatas, Sempes, and Akumajes united under British protection. I love reading this because it gives you the historical background to everything. Then the Alatas, Sempes, and Akumajes united under British protection. And 2 centuries after Alatas came, we find that Alata Manche, recognized as paramount chief of Jamestown, claiming, holding, and giving and permitting the farming and occupation of land on the side of the Korle. The apex court disapproved that the stand taken by the Court of Appeals in the Yaudwade case when it said it was wrong for the Court of Appeal to deal with the matter as though the question has never arisen before. Here we are, 35 years later, we are dealing with the same question this time at the High Court just as Akolache justice dealt with the question, and it traveled all the way to the Supreme Court. We are here again. It reminds me of the great Edinkra symbol, Sankofa, meaning literally, go back and get it. However, in the circumstances of our case, it is a phrase which implies learning from the past to inform the future. The said phrase will shape the form and substance of this judgment. After Akolache, here we are again. Here we are again. Taking a cue from the case of Yaudwade Crab, SC, or Jamestown Stool and Ano versus Sempe Stool and Ano, I would decide this case on the basis of the case law in relation to Gamashi lands. In the above case, the Supreme Court's conclusion was that it would be wrong for any of the three stools to claim for itself all Jamestown lands, and that each quarter can only claim ownership of an area which is in its exclusive possession. Jamestown shikpo GFA quarters ni o Jamestown mokome kura anye teshine ba aka Jamestown shikpo GFA amame no Shimon no ni afo aka ene bonomie no pe obanyo claim no ni afo aka ene Sempe ma no pe anya me claim no ni afo aka ene Alatabia no pe amebanya me claim no ni afo aka ene akama jebi ano no pe jino na mbanya me claim mokonye jameyete na ten ne ba aka ne keshikpo jine fe mi kometo mi no mi. To be in the exclusive possession of each area as a badge of ownership, I would defer to Justice Akolache's version of partitioning Jamestown lands among the three quarters, which received judicial approval in the Supreme Court. So, Judge Nchono Kwake, ake ni ebayano, ne ebacho monino GNA, noni Justice Akolache yue, ye High Court ne te Supreme Court. Ni Supreme Court umano emano mi ake na kanji boni abayele eba yusule na kaino echake no kweni. Nega, before I do that, I must state that the dispute before the court in Yaudwade Crab's case was respect of the parcel of land situated in the then Latebiokoshi known as Memete land. The breakdown of the court's decision is as follows. Echongo kwake. Nega Yaudwade Crab case ne yue shiponko benye nye kayo ake before neke case ne ke ache la tebi okoshi ye la tebi okoshi ni wolele bibio ne shichoko sabu zongo na kanjame fe jeje ke na kanjame fe acho fe la tebi okoshi ni ajala mi na fe le bibio shi neke jagme ne ko kane no la tebi okoshi ye je la tebi okoshi no le tono bi ane na fe le da bi shi jeje nchono gwa ke la tebi okoshi na kanjagme na ya Dwade Crab case mi ka ke la tebi okoshi choko ye mi sabu zongo na kanje gbe fe na gbla mi fe. Now neke case ne na ye ya Dwade case na chono wake na kan memete shipon no juno ni aye neke case ne na ke jela shipon beni ajala le. Now, with respect to the area known as Sabu Zongo, the trial court noted that it was part of Memete land in possession of Alata Manche, and by his sole permission granted the land to Malam Baku, who settled on the land with his people. Ake Sabu Zongwe Alata Manche nomi ni le ekeyamo kona chole Malam Baku ni le hinjame ke ewebi. The area west of Kole Lagoon, including the area west of Kole Lagoon, including Kole Gono, Owene, Choko, Chemu Lagoon, Plaza Cinema, and surrounding areas were predominantly in possession of Alata subjects. Hence, it is owned by the Alata stool. So, Ache Eawake, Kote west of Kole Lagoon, Kole Gono, Owene, Choko, Chemuena, Plaza Cinema, ke majimbibi bi komene petele, jeme Alata bi ni hiyo jeme, ni wa jeme akeha Alata. Mamprobi, including the Presbyterian, Methodist, Salvation buildings up to Kaneshi and western side of Link Road, including part of the parcel of Latebiokoshi or Memete area, opposite New Kolebu bungalows, were in possession of Sempe subjects. Therefore, it belonged to Sempe's stool. So na ke ajala shikpo minfe. No woni jeje chonake mokomenye teshi ne kake ne ke shikpo jinye fe le no mi achombo any Sempe ma shikpo yo. Achombo any alata shikpo yo. Now, with regard to Jankobil, Nyebuatwe, Akola Cheje said the co-plaintiff has satisfied me that the village Jankobli and its surrounding lands are exclusively under Alata stool by the settlements which were made by the permission of the Alata stool. So, neke Akola Cheke ni jeje a quote from me. Jeje ke Akolache ani wali ake neke Jankobli ne kashiko jinkomene bolile fe nue alata biye anomi ye minke nunkane yabwe. The poultry farm was granted by the Sempe stool and under lease to the ADC. The area known as Freedom is for the Sempe stool, emphasis mine. So poultry farm niji jame echono kwa ke nwe a grant Sempe many granting na can lease so it's under Sempe agbene any actual freedom jeme nwe Sempe bi anomi jeje ke emphasis mine le edumono ne ke na ke. The evidence of the parties will be viewed through the lenses of the Akolache decision affirmed by the Supreme Court and that of Nii Amano Akwe II versus Nii Ayikai McLean Supra and the Marco Salt Concession Inquiry. So jeje ke eba dumo Akolache sani ene yene ke blashi konji ya miye eba dumo sani na chole Amano Akwe enyo ke Nii Ayikai McLean ke Marco Salt Concession Inquiry eba dumo neke sanji eteneno ni ekeba ye sani. The land in dispute was granted to the Nii Danso and others in the year 1950 during the pendency of the Yao Duade crab case. The plaintiffs are the representatives of Emmanuel Kofi Danso, who derived his title from Nii Danso. Any doubts about the land in disputes was clarified in the following cross-examination. In the site plan attached to the statutory declaration Exhibit F, the land is situated at Sakaman, Jonkobli, Amisagono, and South Oblogo. Is that not so? Answer: yes, that is so. However, the plaintiff tried to lump the above mentioned areas as Jankobli and surrounding areas, and in his cross-examination as follows. The last time you told the court that Jankobli is the same as Dansoman, do you still stand by that? Answer: I said Jankobli and surrounding lands, and I still stand by it. Can you explain this statement? So ebe back blami no one chele Jankobli ke surrounding towns ni a separate ne back Sakaman, Amisagono, and south of Oblogo. So jaja ke blamomi get your separate Sakaman, Amisagono, and south of Oblogo Mino no chofe Jankobli and surrounding lands. Jaja ke blami so e back blami. Again, answer: Jankobli and surrounding lands consist of Jankobli, Dama, Amisagono, Sakaman, and parts of Tetegu before the bridge. So, ekbla mi fe no one chole na kanji ke ake Jankobli ke surrounding lands say Jankobli ke surrounding lands say Jankobli yemie, Dama yemie, Amisagono yemie, Sakaman yemie, and parts of Tetegu before the bridge. No ji answer ne ke hane ona no ni Sempe bi ejiga agageje chuchu ale aga Sakama ma me no Dama ma me no. So a Jankobli and surrounding land say money across examine le ne e ke da bi ka ke Jankobli and surrounding land say aton Jankobli denche ke Dama ka Amisagono ke Sakaman and parts of Tetegu before the bridge. So I make chombo any echon any ata aga before the bridge na can bridge here in Lenoniji keji wo resource person eba chon wana can bridge e go len we bi e family bo le mi na kan je me gben leje me bo jugba. In his cross examination stated here under about the disputed land DW1 and defense witness 1 DW1 and defense witness 1 admitted that Dansoma includes Pakpopora, Amisagono, and Sakaman. So So this is interesting. So defense witness one leje Sempe manye ni akaneke sanene te eshile achono gwake ni abile sanie ewomiyake ke ake Dansoma a comprise of Pakpopora, Amisagono, ke Sakaman. Sempe manye ni eji defendant in this case under cross-examination here womiyake keji ake Dansoma Pakpopora yemi Amisagono yemi ni Sakaman yemi. Abile sandi. Question: does Dansoma not include Sakaman, Pakpopora, Amisagono? Answer ne kabane. Dansoma includes Pakpopora. The Pakpopora is actually Sempe name, which normally give it to our, which we normally give it to our first male child. Dansoma also includes Sakaman. Sakaman is also Sempe name. The Amisagono is also part of Dansoma. So yes, a form or part of Dansoma mone. She wa fe waliake kpako me Sempe me wo kpako wa fe waliake saka Sempe me wo saka no ewo that clearly in chobu akabe yeles even though ene me fe ba fita Dansoma here ka okwe gbe ni kano Sempe gbe ijino ni kano so yele susumomi ama me no mi nakanji ansande ka even though he admit ake fe fita Dansoma here. Now Abile, you see the land in dispute and the entire settlement called Dansoman were granted to plaintiff's family by Jamestown Alata stool and not Sempe stool. Is that not the case? Ake neke shikpo nena achole Dansoman. Ke shikpo jine bole Dansoman fe Jamestown Alata stool amena meke Dansoman wekue ani jena kainlo manyeke dabi. That is not so. Jena kainli. Now, finally, in another cross-examination, defense witness one, Niji Manye, Sempe Manye, was emphatic that Jankobli is part of Opete Pakpo lands. So, onake leno eyu muenyo. That is where in Kebake a colache case say a specified no feno, but this is how cloudy some of the issues are. In the first cross-examination, eyu ake ebaka because acho neke shiponji ne Jankobli ke neke ni binefe eye Dansoma miye ni asa a cross examine le konwe. Come on. Defense witness one was emphatic that Jankobli is part of Opete Pakpo lands. Ni wali ake Opete Pakpo lands no juno ni akama aje bi e claim ake na ke shiponji ama no. So ani ababila ake ani neke Jankobli shipone is it part of Dansoman? Where ni Dansoman bi ano? Although it is part of Opete Pakpo lands, where ni akama jebiano. So defense witness one, she did not help their case. Bona, but in blaming le tumobeni kobwe mokousu jio mokousu na gbe mokousu shishijeni. Ona boni chon. And that is why we need a judgment like this. Kone clarify no feno ne kake kejebie ke atabiye bono kejebie unki atabiye bono. But I don't think this answer a help defendant say in this case. From the above evidence, the court is left in no doubt that the land dispute encompassed Jankobli, Amisagono, Sakaman, with the following issues emerging from the evidence. A. Whether Jankobli and surrounding areas consist of Jankobli, Dama, Amisagono, Sakaman, and parts of Tetegu before the bridge. So based on the Kenibi nefe, nona sani kote a consider ne. Ani kake Jankobli ke surrounding areas ani awe Jankobli denche. Damashipon, Amisagono, ke Sakaman, ke parts of Tetegu before the bridge yellow. B. Whether Opete Pakpo lands include Dansoma, Jankobli, Dama, Amisagono, and Sakaman. Ni anike ake opete Pakpo lands no ni akama ajebi e ko ake ama mashiponi ani Dansoma fitai ani Jankobli fitai ani Dama fitai Aniami Sagono fitai. Alo Sakama fitai. C. Whether Jankobri, Dama, Amisagono, Sakama, and parts of Tetegu belongs to Jamestown Alata or Sempe or Akamaje Kwata. No anekeshikponji nefe. Ani Jamestown Kwata no. Alo Sempe Kwata no. Alo Akamaje Kwata no. Ona boni ni yo. Kenga Jamestown ano Alata Kwata no. So je ke neke jini bi ete ni eba consider. Now, the issue of Opete Pakpo lands was determined in the case of Nii Amano Akwe Nijienyo and Nii Ayikai McLean, 1991. Ghana Law Review 54. In the said case, the land popularly known as Opete Pakpo was situated at Odoko. So, ka onuko Opete Pakpo na achomboake. Shikpo na acholo Opete Pakpo Odoko Jinoni yo. It was an action instituted against Akamaje Manche and a grantee of Akamaje's stool by the Sempe Manche. What a break right here. Let's go. Thank you. So far, I want maintain one number. But more than no like issue ehami. Ona bonini yo. Koni Oglabi. Nyanachi onuloke. You see the lie in the judgment. How is Sabon Songo part of Mimete but under Alata's stool? Mimete's stool is the adontin of all Sempe, and Mimete's stool is in possession of Tetekpeshi way of Sempe, Tetekpeshi way of Sempe, which installs the adontin. Shatter Drake. I know. Wabakwe noni. Dabi kenye kaye judgment ne jame eni nkanye refer to sanikona yomo ni keboni ojuale na kainie. The question is minwo ni Sempe challenge that portion. You understand what I'm saying? Sempe should have challenged that portion because we are a judge and quote from nakain portion a quote from nakain yaw duade crab judgment temi bona. So you see, that is why we need here in yellow and I'm about to anyways. Let's go on. Nega faith will me hold brief because onulo a quote from a judgment kona yomoni ewe nakaino bona ni so and rely on nakain sandi any a year. Let's go on. In the case above, the Sempe stool describe the boundaries of their land as follows. So Sempe in Baneba describe Ameshikon. Actually, you know what? Let us take a little musical break. Nyami 1 second. I'll be right back. Thank you. Now, what channel? In above case, the Sempe stool described the boundaries of their land as follows. On the north of the Sempe stool land, measuring 200 feet more or less. On the south, measuring 200 feet. On the east, by the vendor's land or the Sempe stool land, measuring 300 feet more or less. And on the west, by a proposed road measuring 300 feet more or less. And adjudged by the Ghana Court of Appeal to be the property of the Sempe stool. that portion forming part of the largest size of the said Sempe stool land. The Akamaje stool, whose land is referred to as Opete Kpakpo, is described as stretching from the Oblogo Road northwards up to the Winneba Road and westwards up to Odoko, south of the Winneba Road, including the northern parts of Dansoman, but limited by the Oblongo Road. So Opete Kpakpo I describe any cover Opete Kpakpo ehabo. Now, it is worthy to note that the above case was decided after the decision of the Court of Appeal in the Yaudwade Crab case, which set aside Akolache J decision and decreed ownership of the said land to Sempe stool. And it is not a surprise that it was captured in their description of the land in dispute. It was also decided that the Marcosort concession, it was also decided after the Marcosort concession inquiry. So, Nekeya Duade Crab case in a set aside Justice Akolache decision, the Marcosort concession, a set in the case is never aside. So, and that is why ni Obanake Jaja referred to Ake Nekeshipone Nekesanene na your may pinye tacholete competing judgments because the Marcosort concession inquiry me a tron any shiponi Sempe bi ano Obanake tacholete moniba you ame a mention agbenenwe wafen wali Akolache sane le we chonshi jeje nke wake Yaudwade Crab ne set aside neke Marcosort concession in because it was decided after Yaudwade case was decided after Akolache the Marcosort concession case. Indeed, in their judgment plan published in the Ghanaian Times dated 24th October 1970 and intended as Exhibit 1D5 Sakaman, Ama Quatrain Village, Amisagono, Dama, Latabi Okoshi, Mimete land was adjudged as part of Sempe lands. However, the judgment was short-lived as it was overturned by the Supreme Court and the judgment of Akolache J restored. So I think Ake Iche Onulo Onake I think Ake, if I'm not mistaken, I think your answer has been answered here. I mean your question has been answered here. So but we JJ make le clark tomobeno chon na kan shimon JJ Supreme Court restore Akolache niye bona ama kaneje me ko no but we ke obo wetuolwe. Again, indeed, in their judgment plan published in the Ghanaian Times dated 24th October 1970, intended as Exhibit 1D5, Sakaman, Ama Quatrain Village, Amisagono, Dama, Latabi Okoshi, Mimete land was adjudged as part of Sempe lands. However, the judgment was short-lived as it was overturned by the Supreme Court and the judgment of Akolache J restored. Yes, judgment ni tumabeno chong me tenefe ekeha ekejame befe asempe me Akolache judgment ni Supreme Court restore overturn na can judgment. It is to be noted that first and third defendants only tendered judgment plans, whilst plaintiffs tendered specific site plan of the area in dispute. So ni chwanke first niji manye akamaje manche amena meke ba judgment se pa ka ba shimo meni meke sane te ni ji Nii Danso weku ame ameke specific site plans ba ni amenchon ni pote ni chwanke amame no. However, in the absence of a composite plan in this suit, the said judgment plan and Exhibit 2 is the closest description, albeit graphically, of the land in dispute. In the said judgment plan, Jankobli, Amisagono, Pakopora, Amaquantre villages are all within the same vicinity. So, because other parties say, I'm a benoko, for lack of a better description, site plan, like I know a challenge now, make by what you make a suit in a mere war. Noni Danso we go ekeba. It is the closest to Nokoni graphically. Obanyo na any pote na chon. Ni lele yana can judgment me. Jankobli, Amisagono, Pakopora, Amaquantre villages are all within the same vicinity. Fair area komeni what call area komi for lack of a better description. Bounded by the Sakumo Lagoon. I'm a fair Sakumo Eboli, I'm a fair Alo Ameboli Sakumo Bona. because mambanina fa, ye fa banina man. It can conveniently be described as Jankobli and surrounding areas, as was done in the Yaudwade Crabs case. No, based on the no, Abanya described the ake Jankobli and surrounding areas. Nakanjiboni based on no need na site plan no need na you can conveniently na describe ake Jankobli and surrounding areas instead of na ake Jankobli Dama. You can conveniently say you call them Jankobli and surrounding areas, as it was done in the Yaudwade Crabs case. Now, Amisagono and Pakopora are not settlers, are not settlements or villages like Jankobli and others which were determined in the Marcosort concession inquiry. Amisagono ke Pakopora agbo tumo Jankobli ona boni to ne je aklowa agbo jiame tumo Jankobli tumo boni Marcosort concession ke ne wo keji ekole no go bibio ko banya ka fita man agbo yi. Pretty much that is what the judge is trying to say, because there are no villages no bakake. These are places they can be on their own. They are too small. Pretty much I maybe I read it too much meaning into noni in the said inquiry, among the various names of villages / settlements that was mentioned was Jankobli and the house built by Amar Quantain and the village, who was a prominent surveyor at the time, being consulted by the Jamestown Alata Manche. Jankobli is a Hausa settlement which is a corruption form of Bonkobri, and its surrounding areas in the judgment map include Pakopora, Amisagono, Amar Quantain village, as they were names not mentioned in the Marcosort concession, and also the Akolacha J's that I see. Yeah, in Kanebi this stood out to me. So ona no wani Sempe bi ke obuame wiemoteni Sempe bi en separate dama Amisagono ke ni bi e kome na me cheche efe na menta na me separate from Jankobli. She judge na nchono kwa ke okwe Marcosort sort concession inquiry ke Justice Akolache judgment na kan bia mi fe na kan gbe kobe aye Jankobli and surrounding areas. Ona no wana buole Jankobli and surrounding areas. You understand what I'm saying? The said names were indicated in the judgment plan of Sempe within the vicinity of Jankobli. Pakopora and Amisagono were sandwiched by Amar Quantain village and Jankobli settlement. It therefore leads me in no doubt that Jankobli and surrounding areas include Amisagono, Pakopora, but excluding Sakaman. So Jajen Chono Gwake ke ebomi na kan benu e ka ke Jankobli and surrounding areas Amisagono yemi. Pakopora yemi, she Sakaman Bemi. Now, in the Marcosort Consortium inquiry, Amar Quantain area and Jankobli and surrounding areas were adjudged to belong to Jamestown Alatas too. The Sempe villages bordering the Jankobli on the south is Dama, and Amar Quantain area is Freedom. Both Dama and Freedom were adjudged to be owned by Sempe Stool in the Yaudwade Crab case and the Marcosort concession inquiry case. So jaja efele clear ke Sempe villages ne a border Jankobli on the south is Dama ke Amar Quantain area na actually Freedom. Both Dama and Freedom were adjudged to be owned by Sempe Stool in the Yaudwade Crab case and the Marcosort concession inquiry case. Jaja Chono wage Marcosort concession identify these areas ne Dama ke Freedom ake Sempe bia ono. However, the court in Nii Amano Akwe II versus Nii Ayikai McLean noted that 1.28 square miles of Opete Kpakpo land situated at Abose Okain was adjudged in Okain II versus Ayikai II 1946 12 West African Court of Appeals 31 to belong to Akumaje Stool. So once again, lenwa chono kwake afo kome bibioko. This decision was given 20 years before the Court of Appeal decision in Yaoduade case. The description of the Opete Kpakpo land was imprecise in the Yaoduade crab due to the court's refusal to join Akomaje's to that case. Nichwage neke description in 1946 case in a 1.28 square miles per kena ake efita Opete Kpakpo no ishimon Yaoduade crab case me na know it was imprecise because agme Akomaje ni amebaba ni ameba fita na ken case. That notwithstanding, the court found that the land was entrusted to the Jamestown stool by two stools, and there was no determination of which of the lands belonged to either of the two stools. In the Nii Amano Akwe II versus Nii Ayikai McLean, Ghana Law Review 54, the decision went in favor of the Akomaje stool, and declaration of title was decreed in respect of the land described in their counterclaim. The case established the extent of Opete Kpakpo lands, which was 1.28 square miles. So Opete Kpakpo niji Akomaje bi ano judgment jine fena kote nchono kwa 1.28 square miles pe. So omo no ba jemi ke ni Akomaje neke 1.28 square miles benuele dabi enye ka ke no efita Opete Kpakpo no. It is worthy to know that Alata too was not a party to the above suit. So we will not be able to ascertain whether part of Northern Dansoman is considered part of Opete Kpakpo lands, even though from the description in the counterclaim of the first defendant in the above suit, it is limited by the Oblogo Road. However, in the Nii Amanokwe Akwe II versus Nii Ayikai McLean, the Akomaje described Opete Kpakpo land in their statement of defense as follows. The Akomaje stool was the reputed owner of Opete Kpakpo, stretching from the Oblongo Road northwards up to the Winneba Road and westwards up to Odoko south of the Winneba Road, including the northern parts of Dansoman, but limited by the Oblogo Road. So I'm 1.28 miles. Now make a sanity. I'm in a stretch northwards, southwards, westwards, eastwards, Cambote Dansoman, northern parts of Dansoman. Opete Kpakpo stretch okay ajeme fin she obana ke clearly na gbena me 1.28 miles square pe ye na kan know me. The judgment plan which accompanied the above case limited Akomaje lands north of Oblogo Road and the lands of the Alata stool in south of the Oblogo Road, so that if Opete Kpakpo lands are not of the Oblogo Road, then it does not cover Amisagono, Kpakpo Pora, which are within the vicinity of Jonkobli lands and are located per the judgment plan south of Oblogo Road. So based on judgment, now 1.28 square miles say anye achono kwa Akomaje bi amenya ameka ke Amisagono Kpakpo Pora ke neke shikpo jine na consider alake eye Jankobli popa no Akomaje bi nye ka ke na kan no eye amenomi. In the above case, the customary law position that was applied was that even though stools may settle on the land, it is the particular stool family, tribe, or individual who had reduced any portion of the land into its possession that has the authority to exercise rights over it. In the Akolaches J's decision and Marco South concession inquiry, the same customary principle was applied to adjudge Jankobli and surrounding areas to belong to Jamestown Alata stool. Nichwage same Marco South concession inquiry name here. The same customary principle was applied. Ni I judge ake neke Jankobli ke majie ni bolile it belong to the Jamestown Alata stool. There was no indication that the said areas were reduced into possession by Akomaje stool or Sempe stool, and they exercised exclusive rights over them. Ni traga neke case ne say no kokla be ake ajie neke shikpo neke wo Akomaje stool em alo Sempe stool emi eni amechunoko over no. The only villages within the vicinity of the Jankobli and surrounding area which was adjudged to belong to Sempe were Damma and Sakaman, which serve as boundaries to Jankobli lands. So achono ga eneke no kone mie Damma nke Sakaman pe jinoni achonke no mele eye Sempe bia anomi. She Kpakpo Pora ke the other one say in chefe no aka Sempe biano ene nke no gwake damma ke sakamampe jinoni afo ake no le Sempe no mi. The case of Yao Duade Crab was considered in Nii Amano Akwe II versus Nii Ayikai McLean, and it was acknowledged that the decision of Akolache, a judge Latebi Okoshi, to belong to Sempe too, and the said land included parts of Opete Kpakpo lands, declared in Okai II versus Ayikai II to belong exclusively to Akamajes too. So any lewe echombo Opete Kpakpo land say noni botio Sempe nomi ke Opete noni botio Akamaje noni. Indeed, the judgment plan attached to the case of Nii Amano Akwe II versus Nii Ayikai McLean did not include Jankobli or Amisagono or Pakopora. Once again, Achono Kwake Neke judgment ne ye Amano Akwe ni jenyo ke Ayikai McLean no mi na ke plan ona Jankobli alo Amisagono alo Pakopora yemi. From the judgment plan, the Oblogo Road serves as more or less the boundary between Dansoman Estates and the land of Akumajes too. Dansoman Estate is south of Oblogo Road. So also is Tunga. The plaintiffs and the third defendant were at item on Jankobli from the answers in the following cross-examination. Jankobli was founded by Hausa settlers. Is that not so? Answer: no. They were given permission by Ngleshi Alata chief to settle there. So you admit that the permission did not come from Nii Danso the first? Again, yes. Question: in fact, the people of Jankobli appointed their chiefs. Is that not so? Yes. Only the Muslim community. In Jankobli, the Muslim community is called Tunga, and in that area is where the Muslims and their chiefs have settled. But in the other areas of Jankobli, there are other settlers who were given permission by Nii Danso. Yes, Jankobli age neke komeye Jankobli na ke ha Hausa me na me ba injeme ni no Hausa me pe ni wo ame manche shije ni moko wo manche jeme yes Hausa me na me yo jeme wo ame wo ame yin enye she called quite other towns saying your Jankobli mean fe na kanje me fe Nii Danso jimoni ekeha. The cross-examination of third defendant also revealed the following. So presently the people of Jankobli are Hausa settlers. My lord, the people of Jankobli are not only Hausa settlers. The Gans, in actual fact, mixed tribe, including some of our people. But chief of Jankobli is a Hausa. I'm not aware there is a chief at Jankobli. The only place I know there is a Hausa chief is at Tuba. The person you refer to as a chief of Tuba is not a chief, but is a caretaker. I'm aware Jankobli is part of Opete Kpakpo. The same Jankobli is sometimes referred to as Tunga. Answer: I'm not aware. These Hausa settlers settled on the land with the permission of the chief of Jamestown, not Jamestown Alata. Again, yes, I'm aware. You are also aware that Jamestown stool comprised of Jamestown Alata stool, Jamestown Sempe stool, and Akamaje stool. Answer: that is correct. And it was based upon the strength of this fact that the Jamestown stool permitted the Hausa to settle on the land. Yes, my lord. In the witness statement of defense witness 1, the following evidence was pregnant. The Jamestown stool had under it 3 quarters or divisions, namely Alata, Akamaji, and Sempe. The head of the Alata quarter was also the head of the Jamestown stool. With the creation of the union, the lands of the 3 quarters became jointly owned. Internal disputes led to the disintegration of the union sometime in 1916. The case of the concession inquiry, number 1120 Accra, Marco Sort concession, popularly referred to as the Wager Sort concession case, led to the total collapse of the union. I wish to tender in evidence a copy of the case as Exhibit 1D4. In this case, the Jamestown stool represented the 3 component stools of Alata, Sempe, and Akumaji. In this case, Dama, Sakama, Impuase were held to be Jamestown settlements. Jankobli was held to be recognized Jamestown village. Jankobli is also popularly referred to as Tunga. Beyond Jankobli, we have Pakpo Pora Ponds, which is the present-day Liberty Down, and which falls under Sempe, emphasis mine. The letter written by the chief of the Hausa settlement, Exhibit 1D 110, did reveal that Jankobli is also known as Tunga. The letterhead of Exhibit 1D 110 reads, Office of Tunga Chief, and the letter was signed by Chief Alaji Solo Baku, whose official residence is Jankobli, Tunga Palace. That they are the Tunga community, and if the said community is within Jankobli, then the Tunga, as indicated on the plan attached to the judgment in Nii Amano Akwe II, this is Nii Ayikwan McLean, is south of Oblogo Road, therefore not Akumaje's two lands, but on Jamestown Alata's two lands, as distinct from Sempe's stool and Akamaji lands. So jaje nchono gwake neke Tunga manchene ke je maleta ye Tunga chief neke Jankobli ne sometimes achole Tunga no neke ekwe plan no ni ekwe plan ni yo Nii Amano Akwe II ke Nii Ayikwan McLean south of it, therefore enye kake neke lands ne Akamaji stool lands ni Shimon a Jamestown Alata stool lands, and it is distinct a solo from Sempe ke Akamaji Shekonjinye. It is also worth noting that no mention was made of Jankobli and Amisagono in the description of the land of the Akamaji stool in the above case. Neither was Jankobli, Amisagono, Bakpopora mentioned in the above mentioned suit as belonging to Akamaji stool. The inference is that Jankobli and surrounding areas include Amisagono, Bakpopora, and Amakwantre village, and they were adjudged as Jamestown village. So once again, judgment rely on it clearly plan na cha Amisagono, no na check Bakpopora, no na check Amakwantre village, judge yake Jamestown village ni. From the searches tendered at the trial, therefore, is evidence that the land was granted to the father of Emmanuel Kofi Danso, who in turn got it from the father and exercised acts of ownership of the said land by granting leases to other parties, as evidenced by the searches at the Lands Commission. So I try to name if I try to lele ne ke shiponji ne fe na che Bakpopora Amakwate na kenje me ge fe lele na fe search say Jankobli the surrounding areas diame ni nu lela ke Nii Danso e ke he bi Emmanuel Kofi Danso ilehun ejeno ni ehien wekume no ni ebe ahun ehonhon. In seal number L215/2001 and AI 23/2003 in title Nii Adote Oboa II versus ICAM Limited and others, and Nii Adam Kwati versus ICAM Estate Limited and two others consolidated suit. The second defendant claimed that the Akukofoto land was adjudged to belong to Akamaji stool in the Privy Council, case number 6419/1947. One of the issues set down for trial in the above mentioned suit between Bawikwate's stool and Sempe's stool is whether Opetekpakpo lands extend to cover Akukofoto lands, state farms lands. Bona. So once again, the case suit ne ayu Opetekpakpo ne so na ga BNF are dealing with Akamaji ebiwa, and clearly to some extent akwa Sempe bi ake se na me fio ake ne ke shipoji ne fe na cho ameno yamilu. In the said suit, the Akamaji stood applied to join the suit but failed to file a defense after plaintiff has finished his evidence in chief and was cross-examined. His next witness also finished his evidence in chief and was cross-examined. Akamaji stood applied for leave to file their defense out of time, and it was refused. The claim to Akukofoto lands by Akamaji stool in the said suit was based on the judgments in Nii Amano Akwe II versus Nii Ayikwan McLean and Okai the second versus Ayikan the second 1946, 12 West African Court of Appeals 3-1. In respect of this, the court at page 36 of the judgment, Exhibit H, noted that by these Ayikan the third is claiming that by the said judgments, the Akamaje's tool was granted a bigger land of which the land in dispute, Akukofoto, forms part. This claim was proved to be false. Once again, so Achona Genene me fe yani Akamaje bi enomi amen claim Akukofoto fe by any AJM yake Akukofoto no Jama menoni. Evidence in this court showed clearly that these judgments, which formed the basis of the certificate, gave to Akamaje lands known as Opete Papo only, but Opete Papo lands of 1.28 square miles. So Akamaje biye na Opete Papo shipon 1.28 square miles per jinoni ameyo. So Akamaje nye ba na me ba claim yake Opete shipon na chole Opete Papo efren ameno dabi ameno ni yo miye 1.28 square miles per stretch, nowhere near the land in dispute. Akashikone na apelio ine Akamaje biye dabi ameka bakwa Opete Papo ame 1.28 square miles efita anoni ayuo ene sani kula bona. Let's go on. Thank you for everyone who stay with us so far. I know it's boring, it's not exciting, but we are doing this for the future generation. Now, again, the plans covering the two above mentioned judgments were considered by the court in suit number L215/2001 and A123/2003, entitled Nii Adote Obwa II versus ICAM Limited and others, and Nii Adam Kwate versus ICAM Estate Limited and two others, consolidated suit. And the court found that looking closely at the grid lines in Exhibit CC. One second. Exhibit CC and the grid lines in Exhibit 12, the land Akukofoto is not within the Privy Council judgment, nor any of these show Akukofoto lands within Opete Papo lands. The judgment 46/1985 does not grant Akukofoto lands to Akamaje. Indeed, the Akamaje lands in dispute is distinct from the Opete Papo lands in the said case. The courts adjudged the Akukofoto lands to be owned by the Gbawe Quarters too. However, with due reverence to my learned judge, that decision, even though has not been appealed against, goes contrary to the Supreme Court decision in the Yaoduade Crabs case, and by the doctrine of stare decisis cannot be sustained. Once again, when you stare decisis, stare decisis, the court tell you saniko ni I'm a calling a kind stare decisis. Like a Jiboni is an ayale. Onyoba nyoba chaki. I acknowledge that the decision was based on unchallenged evidence. However, the principle of stare decisis enjoined the court in Exhibit H to be bound by the Supreme Court decision in respect of the same subject matter. The first defendant seems to have accepted the above decision when he argued at page 59 of his written address that the land in dispute is different from Akukofoto. From Akotofoto. Akukofoto. The land in dispute is different from Akukofoto. However, Akukofoto, which is State Farms land, was in the area called Freedom, which served as a boundary to Jankobli lands. This is evident in first defendant's own judgment plan. So if they accept the above judgment in Exhibit H, then they cannot claim to the Pakpo Pora Amisagono, which is within Jankobli lands. So judgment case in it is different from Jankobli lands. Ni freedom Jinoni serve as the boundary. And actually freedom no serve as a boundary between Nekeshiko Jine ke Jankobli lands. Nika ame neke judgment na womina ke Benuela amenya ameka ke Pakopora Kami Sagono noe efita Jankobli land say amenya ameka ke efita Akukofoto land say no ambako dabi because noe efita Jankobli land say. it is apparent that the decision was applied without recourse to the customary land law pertaining to the Gamashi lands as enunciated in Anege Akwe and Manche Kojo Abebio Privy Council Judgment number 101 of 1924 that by the custom of the Ga tribe, land which had been exclusively used by inhabitants of a particular quarter belonged to that quarter. If the judgment in Jamestown's tool and Anna versus Sempe's tool and Anna had used the test in Anege Akwe versus Manche Kojo Abebio and found that state farms lands were leased to the state by Sempe's tool as far as 1960 without any protest by Bawekwate's tool, then by application of the customary law principle and statute of limitation, Sempe's tool will be deemed to be in possession and use of the said land and therefore are owners. According to the Supreme Court in Yao Duade Crafts case, these three cases decided that ownership of the land outside Ushertown and Jamestown is to be determined not by alleged historical title, but by proof that the land was in use and occupation of the subjects of the quarter. So principle providing title to the land alone is not enough. You should be able to prove shikon obi alo we be alo meni me yo shishi ni yuso ni meni me yo oshishi ni hiono. Just an historical title alone will not suffice, and that is, I guess, the Gamashi principle. It's very interesting. A bale case he said Greater Accra was the way Nick had decided is completely different. Other regions say sometimes even land registry, Greater Accra region is completely different from the other parts of Ghana. Completely different. I find first defendants' argument that Dama, Bakpopora, and Amisagono as Sempe villages and settlements as untenable. BNA Jinoni Egba Sempe Biana. Ona Bonini yo. BNA Jinoni Egba Egba Sempe Biana. Bona noni yo. Je ke Sempe Biye ke amen claim market Dama. Bakpopora. And Amisagono amamenomie ama klowai nie na kan no is untenable. Dabi anya domono anya akechuni anya ayawomi. Why do I say so? Council based his claim on the Court of Appeal judgment in the Yauduade case. However, he admitted that the said judgment has been set aside. Lawyer fu ene nye sempe ma hiye. Na kan no na ewie alo sanene dumono. Ni ewie ake Dama Bakpopora enamisagono sempe aklowai niye. Le lawyer no agree ake neke judgment no na edumono ye Yauduade case mi neke judgment a set aside. So ka set aside there enye ketuni. So judge ke dabi judgment na set aside there enye edumono ne ka ke based on neke judgment e wo ne kan klowai na chole Dama Bakpopora ke amisagono sempe bia no enye ke na kai no ebe no ko no na ba dumono don because na kan judgment are set aside na kan jinoni judge ke. Indeed, in the Marcos work be na water issue 9 pages. In the Marcos concession case, the court was very emphatic on the settlements which it can classify as villages when it said the villages in question are 1 Botiano, perhaps the largest settlement on the land and really deserving the appellation of being a village. 2 Aplaku. 3 Tetegbe. 4 Sakama. 5 Jonkobri. 6 Damba. Alo Damba. 7 Impuase. Begbe. 8 Begbe Ise. 9 Begbe Shona. And 10 Grefe. In the Marco South concession inquiry, no mention was made of Amisagono and Pakopora. So once again, Sempe may rely on a Marco South concession inquiry. Ni judge nchono wake ya Marco South concession a che Amisagono na che Pakopora. So amenya mekendo afitai. Indeed, a Jankobri surrounding land include area in which the prominent surveyor Amakwatre as a building got mentioned as belonging to Jamestown's tool. If Pakopora Pakpopora and Amisagono were indeed settlements worthy of mention, the court would have taken notice. Indeed, the Marco South concession inquiry case vindicated the position of Akolache J as regards Jankobli and surrounding lands, including settlements permitted by Alata Stool of Jamestown. Rojageke, the cake magine fe ni sempe me check there ake fita me no ye dabi akanya amenya me ke fita inakan eja ake keji nakan no eji villages ni shukwe esa aka woni bi ami ku shukwe court work ba woni bi ami na ba che shi court take wo mi ni ke okwa ne ke Marco South concession case ne Justice Akolache no kpagbe ake Jankobli ke surrounding lands include or settlements feni alatabiye mebe akeshi nakano efita Jankobli. From the judgment plan of Yao Duade Crabs case exhibit 2, Pakpopora is characterized by a pond, and Amakwantre building is sandwiched by Amisagono and Pakpopora neke Amakwantre ne ake surveyor ni na kan shikon alatabiye ke hale so jeje nchono kwa neke surveyor ne ni Amakwantre ne ene mention ye ye between Pakpopora ke Amisagono thing ona boni ni yo ni na kan pepe jiboni ya Duade crab case a capture excuse me. Contrary to first defendant's argument that Justice Akolache judgment did not adjudge Jankobli and surrounding lands to belong to Alata Stool, the court adjudged that Jankobli and surrounding lands, including settlements, were permitted by Jamestown Alata Stool, hence they belong to the said stool. So Jajenke Dabi Sempe manye choice any legi first defendant keji e kake Dabi neke majinye ni ebole Jankobli fe no kokura be ni chonke alatabi ke ha jeje ke je anukwale ni shi Justice Akolache ruling ke ni bi efe ni amena chondo kwa ke lele neke shiko jine fe alatabi eji meni mini ameke ha. So that if by his earlier assertion that Akolache Justice Akolache's judgment is unambiguous and clear and need no interpretation, then first defendant arguments it's contrary and much ado about nothing. So get judge first defendant the aya wo miake Justice Akolache sanene ye any no fe clear neke one eje ko e ba ye benu enye kuse mo ne ba ne se ba chake no conclude. The only villages which are a boundary to Jankobli lands are Dama and Freedom / Sakama, which were adjudged to belong to Sempe Stool. So once again, Jajen Chono Kwake Dama ke Freedom pe jinoni alo Sakama jinoni Sempe bi anoshi Amisagono Pakpopora ke na kan village se no oba bule no na chole Jankobli ni no ke obule na kan be no Alata bi ano. For the purposes of clarity, I will reproduce what Akolache J said about Jankobli as follows. So noni Akolache yue Jankobli here no jinoni inke habwe. The co-plaintiff has satisfied me that the village of Jankobli and its surrounding lands are exclusively under Alata Stool by the settlements, which were made by the permission of the Alata Stool. So Justice Akolache Nimo Femo rely on le the same thing like Jankobli. The surrounding villages it belongs to the Alata Stool and not the Sempe Stool. I.e., in this case, Pakpopora Amisagono. In the above instance, the plaintiff tendered judgment to prove possession. In Penera versus Afram, the Supreme Court was of the view that the principle of law is that a judgment in a previous land suit is admissible in a subsequent suit, though one of the parties to the subsequent suit was not a party to the former suit. Such a judgment is admissible as evidence of exercise of acts of possession and evidence of acts of ownership. In the Marco South concession case, the settlements which attained the status of villages were acknowledged and its ownership was determined. Amisagono, Pakpopora were conspicuously absent because they were a pond / settlements which were not worthy of a status accorded to Dama, Jankobli, and Sakama. So I'm in again na ye ne kesanene ke Marco cost Marco sort concession case me achita because because kokwaji fire bibi ni fe ya mesusu momie efita jankobliye so na ba separate ya me tumoboni a separate damma ke sakama. I noticed that the first defendant's written address never made reference to their own judgment plan, which paint a picture of the location of Jankoble. The first defendant, I'm making mention of my own judgment plan now. Ni Jankoble and its surrounding areas. The said judgment plan was published in the dailies by Sempe too as the jewel in their crown after the Court of Appeal decision in Yaoduade Crab's case before it was torpedoed in the Supreme Court. In the said judgment plan, the area of the state farms was known as Freedom, and it was before Sakaman. The only Sempe towns which border the Jankoble land is Dama to the south and Freedom and Sakaman to the north. Nichwake Bakopora Amisagono no me Sempenye claim yake ama meshiponi Sempenye claim yake. First Defendants Counsel arguments is a belated attempt to launch a war of interpretation by relying on the Court of Appeal judgment that has been rendered moribund once again by the Supreme Court decision in the Yao Crabs case, which restored Akolache J's judgment. So once again, noni first defendant niji manye Sempe manye lawyer town efie e town e se wo sane ekaba ni asa agbla sanena yomo me because it rely on Yaoduade case. Yaoduade case Supreme Court set no aside because Supreme Court uphold noni Akolache we so je kpako bia ne obaso wo na kensane ekaba na sa dumo no na akegbla ni bia mi agbla mi yomo Akolache no noju ni aketwoni. For first defendants to argue that the determination of Akolache J that Jankoble and surrounding lands are exclusively under Alata's too has led the plaintiffs to a misinterpretation that the villages of Dama, Bakpopora, Amisagono, and Sakaman constitute Jankoble and surrounding lands, and as if they are vacant villages which belong to Alata's too, expose their ignorance and lack of appreciation of the customary law land of Gamashin as espoused in case law, especially Akolache J's judgment just in Yaoduade Crab's case. Similar arguments were advanced in the case of the Set Kwakupon Saki versus Kenneth Seed, Civil Appeal 1499, tendered as Exhibit 1D6 by first defendant. The court, speaking through Justice Brobe, said the apparently mystifying conclusion arises out of the misinterpretation, and or misapprehension of the Supreme Court's judgment herein, therefore referred to at page 11 of the said judgment. Amwa Sechi, Justice of the Supreme Court, has this to say: I would therefore allow each stool, Alata, and Sempe so much of the land in dispute as Akolache J found in their favor. So once again, Nichwake say me wa exactly na kan sanebeko jaji eke dabi mofemo no ni Justice Akolache ke na kanji boni makpene ni okole. It is the contention of the first defendants that plaintiff did not lead any proof of the acquisition of the land in dispute or evidence in proof of Alata's tools ownership of the land in dispute. He relied on the case of Majolagbe versus Labi, 1959, number 1 Ghana Law Review 190. However, I have stated in number of cases that proof must relate to the circumstances of a case. Application of the principles of Majolagbe versus Labi has become the Bermuda Triangle for lawyers and trial judges, especially when it has been applied generally without the knowledge that it has to be done with regard to peculiar circumstances of each case. Pega J.A., as it then was in Zamrama versus Segbeji 1991, number 2 Ghana Law Review 221, gave currency to the above review when he said, in my humble opinion, Majolagbe versus Labi should not be taken to have stated a general principle in proof in law, but the way or manner it is applied by some trial judges suggests otherwise. the case must be limited to its own facts and peculiar circumstances. That is to averments capable of proof in some positive way. By this, I mean averments which are of such a nature that they can be proved by the production of positive or direct evidence. In such cases, mere assertion on oath could be said to be adequate. The above views of the eminent jurists found support in the article of S.A. Brobe titled A Digression on Proof, 1961. When he opined, Curry versus Richter and Majolagbe versus Labi might have been overlooked if both cases had been treated as authorities only for proof of possession of land. But it has in fact caused unnecessary confusion because Majolagbe versus Labi, so-called over the years, developed into a rule of general application. Used as a rule of general application, the true Majolagbe dictum will sometimes be fallacious. Why did the venerable jury say so? The answer to the above question will take us on a journey which might look prolixous. However, if doing so will go a long way to make the principle clearer to lawyers, judges, and litigants alike, then I'm prepared to be burned to the stakes of brevity like William Tyndall to achieve that goal. Izambraba verse Sebegbe. Bega J.A. took pains to explain the origins of the principle and once again, a case is not Sunday. I don't think it is really needed. Because we are about case is name, we don't need it. Okay, I'm a candidate. It is worth noting that the proof of ownership of Gamashi lands does not lend itself to proof as laid down in land cases. Generally, rather, it lends itself to the applicable customary land law of Accra people as decided in the three cases referred to in the Yao Duade Crabs case, Supreme Court. The cases determined ownership of the Gamashi lands on the basis of possession of such lands, and the test which was applied was the time-honored ones in the three cases, namely Manchanege Akwe versus Manchakodwa Bebio, Tete Kweku versus Paco Brown, and Hammond versus Abebio. The Supreme Court in the Yaoduade Crab consolidated acknowledged the test applied in above mentioned cases when it said these three cases decided that ownership of land outside of Ushertown and Jamestown is to be determined not by alleged historical title, but by proof that the land was in the use and occupation of the subjects of the quarter. So once again, outside of Jamestown, Ushertown proper, about this side land, fair land case, he said, just the historical title alone will not cut it. Judgment in Kewake, Sana Kwaka Nakanshikon, Name Abi, New York Nakanshikono. It is therefore to be noted that in any dispute about Gamashi lands, the above named cases provided a test for determination of ownership of the said lands by the various tools in Gamashi. If Justice Akolache applying the said test, adjudged Jankobli and surrounding lands to be settlements permitted by Alata's tool, hence they belong to the said tool. The inference is that they are not vacant lands, but lands populated by subjects of Alata's tool or quarter. Justice Akolache Dumono, they can decide in the case in Benitrake, Jankobli. The Shukmanji anybody le fe Alatabiano, ni chwanke, but Nakambia me, I approve a J title pen and Yeshalatabi, Jimmy ni me yono, ni a mechuani yeshipon, alone me ni mechuani yeshipon, no, Alatabi, Nikehame. No, the Alatabiano. The above inference was supported by the Supreme Court in Yaduade Crab's case when it said at the end of the trial, Justice Akolache dismissed the claim by the co-plaintiff and co-defendants tool for title and held that the claim by each stool must be proved as to which of the stools has the predominance of each subject on the land. So once again, Papa Lene Sempe Obana can make reference to nature no guake. I use or numbers. So nama B P O Shikon no. Nakajinoni by each stool must be proved at which of the two stools has the predominance of each subject on the land. So nama B Aifa Yanakan Shikon. In effect, Justice Akolache's judgment was not determined in respect of vacant lands, but lands occupied by subjects of stools. First defendant's own admission in the following cross-examination is pregnant. In page 10, paragraph 4 of Exhibit 1, Jankobli, and surrounding lands were adjudged as Jamestown Alata stool lands and settlements. Do you stand by that statement? Eyansaji, yes, Jankobli was given to Ngleshi Alata. This was because they made settlements for Hausa settlers. And they are still on the land till today. Even before Kofi Akrashi, the then Ngleshi Alata Manche was installed. So the land in question has already been given out, so they cannot claim same. From the evidence, the plaintiff could not provide evidence of the grant to his grandfather, though the denial of the said grant by the defendant implies that he has obligation to prove same. However, the unavailability of the said document should not prevent him from relying on other pieces of evidence to prove same. So even though what I need and so ke won chair amenya me proof amenya me ke grante wolu aba jaji ke dabi ke grante beje to be na me ke la esha grante amenya me ke other documents ko aba ni ba chon, and of course jaji ani one ake search na ma fair lands commission e reveal like lele akena kan shipon eni niji Nii Danso no jaji no ba na ekoti case ko ye bi na kan. From the search exhibited, it was 2 pages. Emmanuel Kofi Danso, also known as Nii Danso the First, is a subject of Alata stool, as well as custodian of sub-stool of Alata with Alata, with oversight responsibility over Dansoman, as exercise acts of ownership by granting lands in locality of the land in dispute without protest from any quarter, especially the Sempe stool. Ake Nii Danso ni can claim ne ke shiko jine na yu osande e ke hame ni Sempe bi etekoshi awokodan. The inference is that the land is in possession and exclusive use of Alata stool. No wo wabanye wadumo no ni waka yu ake ne ke shiko ne na achon Alata bi ashikon ni. This inference is consistent with the test as applied in the Yaoduade Crab Consolidated Supreme Court case. I also add that there was no evidence that Sempe or Akamaje stools have predominance of their subjects in the area and also exercise acts of possession or ownership over the land in dispute. So jaja unchono kwake Sempe ka Akamaje amenye kwa me prove kula ake neke biami na ke shikonji ne ha ama me webi pi ni yo jeme amenye kwa me prove aka me ni yo jeme ame webi fa Alata stool ona boni nchon. So mind you, a very interesting and what can say anytime ni shikon e ba je Jamestown ke Gamashi alo Gamashi Osha town proper ka ja je ame ani what can say having a holistic title alone will not suffice. You should be able to prove you have majority of your subjects ye jeme no jinoni wache na enye Sempe bi aye ni ntwen habwe ewie the numbers game ona. So jaja chono kwake biamina ye neke sanene Sempe ka Akamaje they were not able to prove amame subjects fire jeme fe Alata bi ye nika jobu ade Nii Danso ni ji number 1 leji money ekashikon ha hu ke bata biane. So Sempe ka Akamaje nye ka ake na kan shipon amame no. Even though Emmanuel Kofi Danso's list or conveyance was not produced, he was able to demonstrate from the search report and judgment is in his possession his exercise of ownership of over the said lands in dispute and title of his grantor. To add to, he was able to demonstrate that he is a chief of the sub-stool of Alata stool with oversight responsibility over Dansoman, a name which loosely conveys the entire Jankobli and its environs, including the estate. Once again, even though neke conveyance ni ninke ha wache Nii Danso bi ane na conveyance search ni Anaya Lands Commission prove lele neke shipon ne Alata ya Alata mi ni na kanjeme ye Dansoma no mi ni ke obogbe Danson poto ye obanyo interpret le loosely ake ni Jankobli ye mi Jankobli ye Dansoma mi na kanje fe obanyo call loosely ake lele ke ameke shipon amame no mi amame no. Dansoman was established after the compulsory acquisition of lands of the 3 stools that constituted the Jamestown Paramountcy in 1968. The fact that Nikojo Danso was installed Manche of Dansoman under the auspices of Alata stool without protest from any of the other stools dovetails into the position of the Alata Manche as dominant stool, because the Alata Manche is the one who occupies the Jamestown stool. Once again, now to Nikojo Danso ni jikenkle ake Dansoma Manche Alata Manche ni domoshi na tole ni neke other stools na efe ametemoko eyue noko ebashi Manche ni ato yejame. So like I said, onyo kuse no babiane no bakake na kanshipon bonomi. Plaintiffs have not been able to establish their grant of the disputed land from the Jamestown stool. However, if Jankobli and surrounding areas, including settlements, are adjudged to belong to Jamestown, and 4th plaintiff is a subject of the said stool or subdivision of the said stool, then by application of the test in Anege Akwe versus Manche Abebio and the decision in Yaudwade Crab Supra, the land belongs to the Jamestown Alata stool. The 3 aforementioned cases have established the test for determining the ownership of lands in Gamashi. Therefore, Sempe and Akamaje stools cannot extend their ownership of lands to include Bakopora and Amisa Gono. Full stop. Jeje egblamin fe. No running kani abu efe jeje ke based on any Sempe ka Akamaje. Amenye ameka ke ameshikponjiye e cover Bakopora ke Amisa Gono. Amenye ameka na ke. So Bakopora e best Sempe manomi. Amisa Gono e best Sempe manomi. Na kanji boni judgment ke Jamie ke. Like I said, wache ni nchwa eyuemo omoke olele mi tabo fa ye ishiba mi tawe number obanyo kala yue masumoni ma opportunity hu ni no no ewo ni kobo yuemo to ba na ke che Bakopora right cha Amisa Gono na UFN che femi she judgment ne nke da bi na kan no Sempe menye claim ake amame no ni ona boni ni so masumoni ne woni e ka ke no woni e ke no pa agbe ne ani wole. From the assessment of the evidence, the court is of the view that just as the Yaudwade Crabs case started as a case involving individuals and metamorphosed, into that of a case between rival stools, this case also started as a case between the family of Emmanuel Danso and 2 stools, suffered transfiguration into battle of stools previously allied to Jamestown stools. Lawyers. That is why most of the time a liberal arts be in your law school. They are so good with writing. I mean, judges, once again, especially lawyers, no need to judges. The evidence overwhelmingly tilts the ownership of the land in dispute, i.e., Amisa Gono and Bakopora, in favor of the Alata stool, whose land are south of the Oblogo Road. The Sempe stool from the evidence and judgments are not owners of the lands within the Jankobli vicinity, which includes Bakopora lands and Amisa Gono. Rather, they are owners of Sakaman and Dama. So Sempe me akame shikponjinye Sakaman ke Dama pe shiko Bakopora shikponjin ka Amisa Gono shikponjinye Sempe me jiama menoni. Consequently, the action of the 4th plaintiff Niji Dansoma Manchebiane ni Kojo Danso ni jienyo leji 4th plaintiff le lead in kone. Consequently, the action of the 4th plaintiff succeeds and the court grants relief to the extent that it is Jamestown Alata stool land and in possession of Emmanuel Kofi Danso Nije Papa B, D, and E. Nominal damages of 5,000 is awarded for trespass and 10,000 is awarded for cost. Signed, His Lordship Kenneth Edem Kujoji, Justice of the Supreme Justice of the High Court. Excuse me. So energy judgment ni what can the name? So once again, the Sempe stool from the evidence and judgments are not owners of the lands within the Jankobli vicinity, which includes Bakopora Ponds and Amisa Gono. Rather, they are owners of Sakaman and Dama. So clearly, Obanake noni wakande ne chobwake leleng Sempe me they cannot lay claim to Patopora Shiponjie ke Amisagono Shiponjie. She I'm a uni be come ye judgment name. The wanyani wake Nii Danso secretary wakele and thank you for everyone that has stayed with us so far. We've been reading for about 2 hours now, I believe. So ke onyo tashi ni obo watwe for the past 2 hours nyumo ajobo wa adienche. Nya wa bringa Nii Danso secretary keba akpano ni wakele agbasani ije ofane mimba odin omanye ofane te oyoten
ngodrumo inche
efe make yes omanye abla wofen ofane kenye nu clearly nya ni mana ye chat section ake nyenu clearly ojogba de nche ikane judgment say I think I got the relevant portions ni about set case in taking time he spent over 2 hours reading it Koni actually close to 3 hours Koni to able like any call amena any near fan camp clearly jeje anyone awole ake jankobli ke majin bibi alo aklowai bibi ni include amisagono ke pakpo pora alo pakpo pori ake minchelo ojugba sempe bi enye pakpo pora sempe bi enye eklemi ake ameno shimon a follow under alatas too and to that extent but Danso wekue because anye a provide searches ni choage lelen ake ni akrashi ni jienyo le ekeha CA Danso ni lewu eshinkia ebi ni achole Emmanuel Danso ni ji Nii Danso kenklen dani lewu ebi Nii Danso ni jienyo eba eneke no kone only initial thoughts ani ene making a case ni make all these while hamble then what be some other questions
icheke ma body manyeku ni manga buko ichife ke nyeme bla bla de ko de veni bu otu ngene bekene to mo be no yue anpale shi ida ke no poten no okete kote itu ani bofo chole claim say alo release say kote e fe awo mo ni you not no ni pene e awo mi no di ni woka kun ma tuji ke structures ni ojene she release alo claims na kete T3 FN you know here o mi the order for demolition of structures no pay you know ni kote e ke no le pene wo ya no kwale mi judgment ni kashin alo sani ni wokete kanme kote hin na ka pepe kote etile no wo oye mo no jake wonder kote ake ihani anu kwale jipo bo ni ma yue no jino
eshe anima bi ake inkane ni bi na amo no ni wolu eke ne shi miniba ni nyeke sande na eti kote kaji neke no ko kashi ake all these years nye claim to moboni kote to nyenye to manche ya me Danso ma manche cover neke na efe minika ba ni nyeke case na eti
be ke ma ba no ekun sani eji ake
you find nyani 1 second if ma ke moko etwale ni reconnect nyale 1 second yeah nche o find ya no agbene
September 2009
okay
ni woche ni correct Danso kenklemo ete immediate abo wo balake basani afunle to be no wole akeke manchepo aye kusun ke gbejiano to na fi odan ya ke to wole wo ya fi enyo se mi dana to le wo be ma yu ake ma yu before mi be 2011 dani anyele ato wo be ni atole ni ke 2011 ni to ake be ni egbodu 2009 ke 2011 yin noji no ni sempe me ka kumaji ka me ti ya me ko tape measure awo Danso ma shpon na bon from eja ke naka bia mi no mi Danso woku e ke Ngleshi woku e fin ya fo di no na me fo eja ke ameche egbeshi wo akwegbeja no to ne akwa afure beni afun woche ni di 2011 afun Nii Danso kenklen mo emi October na ke to Nii Danso ni ji enyo no she be not to Nii Danso ni je no ni eba ni naji court cases babao mini disanie shikmo ni eche Nii Danso kenkle mo ke ha me Sempe da kuma je bi e cloche pon ve no bala ke be me be Nii Danso kenkle mo ne na ekwete eto amojo Rocket Danso sen ke wo ku et a different courts ni ebala ke be asani anyemi ni akwa na ba fi wotemi Sempe me ke akuma je bi ne amega shmo je Danso no si Danso be no ko komo e Danso ma Danso ma na to Danso ma manche no ko be ni baba ko e je me bo be ni e ba je police station ke je 2012 mo bon police stations ya bo anu ana ke be Sempe manye e ke Sempe manche ji mo ni ke ni hale ni Margaret be ni estate developer le we anu le ake akuma je manche ji mo ni ke shpo hale si Sempe manye ni e ke Sempe manche ke hale wo chi obenke Sempe manche ni adoto buo na kan bia mi 2012 e ke da be ele Sempe manye ko si e ke shpo ko won ko e akọ Sempe manye ko alo Sempe nyogo iwale ni akọ Danso manchmo e ja ke le be ami ake na kan shpo Ngleshi shpo e ja ke beni tete peshi na 1970 judgment tete peshi egbele se mi money ba je ba dumoshi na ke twataji le ni adoto bo no ni adoto bo ele 1990 Supreme Court judgment ni wa chafu 1970 judgment ele ojugba do ele Sempe usu de Ngleshi usu do ba Ngleshi no mi ni lewo ya no wole ake e ba ni na ni ko Danso kenkremo ye manche ye limri no ele ake deme Danso yo je no ni ya ko kan no ko le ta o e ba na Danso kin ale ni Danso ke tete pesin bi ami e gele ojugba no te ba fe te ne ke no be e sina to china te ba san wa court she court na no ba na Sempe manche ni le Sempe manye tun ake e ke shpon hale but court ni o ka meti no ji no ni onye wona ake be ni adoto otinto leji moni ke iwale ha le Sempe manye ke ichi ni ama cross Sempe Danso manchmo but esisi ne
Okay.
esisi ne si going along the lane Sempe manye ila twese no ne ba twese be asani abachakile yesani em no beni abachakile na kan bia mi agbene woche ni ji ni adoto bo egbo ke ba kwa egbo 2018 ni na kan bia mi fe ne egbo 2018 no mi ko boni ka bo na fe no me Sempe file ko statement of defense
I see.
no after 2018 ni adoto bo egbo na funle na kan bia mi ni woche ni adoto otinto le won agizetle ake Sempe manchi but ko kwe exert extra ne yin wa na ke ba to le 2016 atole 4 September 2016 ni pe nature of change ake 1 September 2016 ni adoto bo he abdicated from the stool into akele yen cheke ye manche no
Right.
Robert nakai no 2 years later ni ake exert wache ni adoto otinto in 2018 but that tells you clearly ake but bia mi ni Sempe manye you ake ni otinto ke shpo hale ni hale wale na ka bia me ni otinto je
Sempe manche.
that's right wale po na ke ha
That's right.
che bala ke je manja che man sani wo yo wonyo sponsor wo ni bala ke wo asimo ko sponsor ni wo ye wo ni etwense ni le manye etwense moni ba chakele ji ni madu ni le hani hotel la ke le ji shipi kan Sempe sen ni Sempe sen hale wale ke wo ku e fin hale wale ni ba ne ba chake ni ne manye ni ba dumo sani na no ni wan na ake Sempe manye substitute by ni madu do ne ba chake Sempe manye then in 2019 they filed a statement of defense ni nu ele bale clear na ke be adoto tinto ni ke iwala ha ni ame fe ame ye shensi ne fe na kan ne file defense ne fe counter claim ne fe e kan ni ale aga shipon je English shipon si Sempe shipon no ke Sempe je English shipon ni English be wale ne ke ku ma ha ebi wo na kan grant ni Danso you ya ke ni ko fi akashi ke ni amo ame convey ke ba it is invalid
Right.
ni ame ani kotel ya ke shipon na to dama papo pour remis angono fe Sempe shipon je English no na me be recovery of possession na gbena me bi na restrain na so ku Ngleshi woku me fe mo fi amo de yo na gbena shipon ni no fi amo ni Ngleshi kin amokwalo Nii Danso e kin amokwe ni kote akumo na ganchu ni fe ya e wala na akumo na ganchu ni fe na e cause against wo. But the genesis of the sani e beni etel e jishishine the balake be asani abuti adekami adekami ni ma do ni le hana la ke le jishipi kin Sempe e buti adekami agbene ameka another witness ba fita ni Michael ni anulati she na equity no mi leji two secretary kin Sempe le wo yana le ake Sempe sen ale wale ni e ba ne ba yuda sin kin Sempe sen wo ben loji no ni ona tombe no kan yo le jeje till stage by stage case ni na ye ni tombe no yo le 2015 start the first judge ni is statics kan ni actually justice tokan legislation ise equity pension ni agbeni akmaha justice asarenyaku lehun ibanye ni lehun a transfer le dani semi ni na agbeni justice Kenneth Edem Kujoji wo judge se ten ni ame question na una boa bo kemoko eteshi to be ni wo the ajue judgment ne the ajue le be ni ajue ni court ne anwe ake judgment ni almost 10 years kese ni ame kwamia in the number of months ni judge ne use make my judgment ne she ka be no kanile 3 hours kese ne na ka no judge won kanile ene ni judge kanile na gbele court ha summary judgment if you have summary judgment it can line by line to be no notice no kind of line by line even excuse me but no upon again on authority say ko mo tun she let authority say it can because ele aka benike say yo ke after summary judgment moko ba attach ne ba wi lokoko moko ba wi lokoko well it can for over 2 hours no je no ko ni tumo shomo no ko ni ka onu no ko shishin oya egbe no ya for interpretation you're the same judge no kagbene you are not satisfied with the judgment why not appeal on abedin to she ka fe press conference ni oye ni judge court kin ha bo fi no ka ken ha bo ni agbene ni o ke me ake they should know judgment credit say ake ka me ba je ameka for me da do ha me assisted this mo ni me ameba ni ameba na ba to tenancy abo then what you are saying here of crackers be kulabo na judgment there are certain orders ni court ham so counter crimes no fear fin court e ko kra wo
right so
counter crime first defendant fear court e ko wo
Anima Bibo based on some of the things now I'm a press conference here. Clearly, I'm in Chono Gwage, the portion of Jankobli, ni Akenya, it's only 14.08 acres. Jankobli Shikpon as a whole, I know actually based on your case and your presenter in Chono Gwage and surrounding areas. So it goes beyond the 14.8 acres. I may identify I can know per Ginoni I can hanye Jankobli Shikpon ke surrounding areas if you find only acreage off head obanyo awon aka acreage
ka ma je oyo mo shishin won na me wi ake Shikpon no get 14 ka 40 kwa page 21 of the judgment the Shikpon no ke shed the learning to judge paragraph 9 it is in two folds e come 14.8 acre ka be na come 14 acres ni won we akeshi from the pleadings of the plaintiff as the judge even ascribe it portions of Jonkobi and surrounding lands ni amame trespass alo ame encroach portions of it but na portions say no chon no di no ni wokeba court ni di 40.08 ke come 14 acre do any focus ke cha is over 20 acres
meaning ake ka member amabono ama ni meaning ake be ke oje portion say ni ame encroach or no the rest of any wachole ake Jonkobi e fe ye danso man shishiomo Nii Danso shishiomo it's just the few portions okay got you
it's just a few portions
okay
ni amame encroach no ani ni won yakote woke apart from numu grant na hale ni wona no fe there's a statutory recreation one wa fe search official search the lands commission In to many years, there are some of the searches said work about. It won't pay there's a grant. Chet won't Nii Danso need you can claim more in my confidence. She boy can't me. Ni me one man register ni me beg one nine man confidence to so and so. Man confidence 1980, 1985, 1990, 1992. Well, the two about the exclusive ownership. Okay. Ni again one you can have a grant. So when you are catching apart from grant, the Nii Danso le ni legit Danso no money. No me baba o ni chon ake shukmo lelele no ni kota na ake ni o jimi ni nyenye ni se pe ni no ne ba to be ni you 2009 ni Danso kenkan mo twen se ni nekani bi na tishi e ja ke no mi che ni yo je me e twen se lo ni che twen se mo fia mo ba o temi
right so question ni mi nta o ma bi ji ake clearly jeje ani wo na wole ake ke oche dama ke freedom alo sakama sempe ma no you are not laying claim to shikpon kone your damman ke freedom ke sakama me. You guys are not laying any claim to neke portions ne.
Ake ka wo claims wo keti wani koteli to be ni ona ye page 20 they talk about the size of the land one quarter cable noni walkeba okay we made it clear okay one Jonkobri shikon ekome ye Jonkobri and that is Danso ma Jonkobri emisangon that is Rogi 14 acres say ka gbene ekomi won is meaning Danso ma Jonkobri Noji shikon enyo ne di noni wakete ni wani kotel yake shikon enyo noni waton ne ye Jonkobri and surrounding lands noni akolache ajajake it belongs to the Alata story Jonkobri and surrounding lands see amame fe am counter claiming so they brought in go back the page 2 the first defendant they filed a defense in July 2019 a counter claiming they made it clear a declaration that the land in dispute form part of Dama, Papopora, Emisagono, and therefore Sempe 2 lands.
Right.
So it was them who brought in this Dama and Sakama issue.
Okay.
Ona be no kake Dama ke Sakama fe Danso mani. Ye bia mini Danso ma wono no ni, but Dama ke Sakama won be wono.
Right.
Ona yanika obakwa ekome. No me jeje nwa keshi. No me we were in cross examination. Ne abiake ocho no ni constitute Danso ma. We added Damake Sankama Gavita.
Right.
Ejake in their pleadings say amame ani kotel like Danso ma me noni.
Right.
With the exception of Jonkobri niji yeni Hausa mayor niji Tunga. Amame ana like apart from Tunga pe ji noni Ngleshi no. See Danso ma fe amega Sempe noni. Ona bi ni yo. So won ka ke so ka ne ke sam Danso ma fe noni ni ne ke Dama ni wo like Dama je wo no. Sakama je mo. Si dia ne lam sam fe ka wo Danso ma musumie. Be ka wo Danso ma wo no ni. No so no ni wo Danso ma musumie. Be wo no ni.
Right. Eshe. So the claim also from our press conference Ijakeshi nyehame pretty much threatening people ni ye Damma shikpono ke Sakama shikpono can it be is that claim correct based on this nyete nyeke ni bi pete okay.
Amale ni Ijakeshi ko judgment ni kan she nje. Sempe me nje amenya me describe aname shikpon na me ga me yo. Kote ewi amenya me describe amame shikpon ni amame yo ni kote po ba nake o shikpon start e bi etumo be ni kote ewi akashi we were able to describe our land there koke page 32 ne e kon ba ke land e show boundaries with state housing ka kuko photo Sempe could not describe akashi shikpon ni je ke Dama no Dama ju Sakama ngbe Dama ngbe Sakama it was a judge ni le e judgment plan say ni they ton akene ne north in the south, but Sempe could not describe their own land, and it was clearly there. Page 32,
right
21 page 21 where you if anything, it is the first defendant who has not identified the land granted to her by the Sempe.
Yeah,
many by you that say can le manyene ne twen say ni ma do ke I'm a secretary na amaye they could not describe yani Sempe start to ne agbe ona ye well ni bo nyu ton yani Sempe George de gba te flo ton na ga na te da mani because court no le ake papopora no ne ton ni ne ke ka for Sempe nyu kenklen mo binu awole papo court nga yo mo shi papopora fe na nubuini to me ni wo to le bro fu me pon say
right
te nubuini ni bia ne ni amba bia ke ngbe na me ton ngbe ni te nubuini to be ni le Sempe nu de fe press con de yu ake moto mi na kan de ton i ke da mani je me moto mi ni court an o le ake papopora na kan choje ke mi sango ne han o le ake dama jonkobri ni jitunga ke sakama chu akrowa ni na ma meye dani abafe dansoma ni tumobe ni ole ni mu le ko yen sipon pe eje ke eye 50 years lo sipon pe eje yen to sipon pe pa
dabi
sino ni no sipon pe eje ba yen feji e ba increase in value e ko le ka ni se 10 years ago awon le 5 cd me na ma awon le 10 cd si sipon pa eje no yo ke eye 20 years enye fe sipon pa nyuma no ni dama ni yo tutu dama no no yo tutu sakama no no yo jogo bi ni mene no yo tunga kote oba na usa meje oba na usa me akeshi it is already an occupied area no ke oba se ni ne ke ye kota ke aye ku na chole dama jomi moko eko jomi mi jegbe o shian jomi moko shian lo shian ko no moko shian no ke o ke o je jomi ta choje ten no ka get dama jomi mi no ke ko ta ke dama jomi se jomi fe dama ni ni search report na yin e kokra ko be no ba na Sempe gbe ye ake mi Sempe e grant one plot of land ke ha mokopo ne ba na official search report no ko na kan be supon be dama supon be sakama supon be dama supon be saka amedinche in their own cross examination admitted ake papopora they were not even making the Sakama issue seriously. They were saying ake papopora. Wa me like any support the yo di papopora. Tell me sangono. No ana me yu ake papopora ma me no ni na ma me te no na me yu ake ka for Sempe binu kenkla wole papo. No papopora ma me no ni. Emi sangono ma me no ni. Ona benichon no ama me die chameli ni ekome ame yue mi po ake papopora ke mi sango no papopora no dino ni achoje me keep it down the keep it down ko se keep it no te down ngbo ya o ya papopora na kan je me ji ya ni ekome mu choje o tojo akuma je bi on choje me south to doko shaha na me lia ake na kan je me fe no dino na fe achoje dansoma including the dansoma estate na gbile na mi yue mi nu le yu ake dansoma estate wa ma me no na me ka manche somebody paje fe iko ten kenya ke estate ni oje ni danso no ni no na egbe kan no dansoma estate ni ke government e ba ko lele ni ate ko mene ni ke bobi one suit number BL 261 so 2004 ni ko danso ke lands commission ke attorney general wo yen judgment ni court e ba compensate family ni na kan shpon ni kan shi na ke fi estate it's over 1700 acres wo ke lela ke nyen no mi no never fight it e ka ke no ni Sempe judgment ni Sempe yen ne ka claim 10% of the Dansoma compensation was 1970 court of appeal judgment na pay 10% during that time na pay ba la ke ba fa treasury bills ni foundation na pay she na wo 70 achafon they couldn't go for the claim any longer because no na the asset aside from no you awa achafon no ni ke bo bi an ke government bo fi serious say ska na pay am based on that 1970 judgment they have to refund that money ona be ncho no ke bi e ko me abumo no esa anu mo kejopo no mi shu e jake no ni egba ni ko danso ni danso ma manche no jake beni ajesan ni ehin ni bi eyan no wona ke o bi na me ke langa bu ajen ke ni ke lela ka agbesan ni na aka agbesan ni na ona be ncho be Bena wag bena best na me ho fe.
Right.
But anyway, I was seek for an injunction.
Mm-hmm.
I can restrain all parties.
Right.
They fiercely resisted that.
Oh, I see.
I'm shia jina me shpo jina me kan me ni me ma mo shia jina me ni.
Mm-hmm.
I mean any content like shpo je dey can follow.
Mm-hmm.
Shpo jina me baba we na me ni me ma mo shia me ka me bi ka me ho yen. No ka restrain me no. Ngbe me ba o.
Mm-hmm.
Content na ke lela no kwale ni.
Right.
But a grantee injunction.
Mm-hmm.
Na kan injunction na grantee mujino na me ke sembo de bonje pa ke be ame
no.
yes.
Right.
We balake be nyemonu wo yin basani wo ya kote.
Mm-hmm.
Wo ya ni ke wo na ha judgment agbeni judgment be ni wo ba na le.
Right.
Ni wo ya le na kan.
Ishe.
Wo yo mo ni wo yo no.
Amabibo so many ameyeshikon ya amedi. Ni to once again jeje eha nye na kan order ni nsi ka structures ni yo no fe akuma ahwe. So many sempe bi ho shikon eha me ni ame mamo eni bi ame no. Mini jino ni neke na kan gbe me mini gbe no nye jino ni nye ka me ba chon.
Okay, but ni aha judgment ni.
Mhm.
Modromo na beni aba kan judgment ni. Sempe me fe ni ma do ni ba dumo she first defendant na.
Mhm.
Ke ni ayi kan mo ni ba dumo na hale.
Mhm.
Ame fe ka me chi fe ye kote.
Mhm.
Bro jeje read no fe anu mo fe mo na.
Right.
She the issue edi. Bi ade ni ke bo yo mo fe mo ye copies.
Mhm.
No ni je nyoji ka ha judgment time for you to go to execution of the judgment.
Mhm.
As I no file entry of judgment.
Okay.
What file entry of judgment? Even though on your server, me court what they were bit subtest service.
Mhm.
In hand work out carpet me palace say.
Right.
When you go what ka ko apete akuma ji palace say Jamestown.
Mhm.
Sempe jeme amema tuehi.
Mhm.
We balake ko kapete pour le cement ba pam no court
Mhm.
no obile. Na ke ni ma adoe eye kolebu sempe kolebu manche we
Mhm.
your St. Mary's School, I say,
Right.
Wahan work apete, and walk apete again.
Mhm.
Then I'm going to Margaret and work at Tation work apete.
Mhm.
What I have 14 days. After 14 days,
Mhm.
you change.
Right.
But be any workable you or they send you me.
Mhm.
Three order for possession.
Mhm.
Go by execute order for possession.
Okay.
Ni many shia
Mhm.
ni affect spawning
Mhm.
ni what na no no feji. What na even though no ka pete I'm a palaces ni many amekashia amkanibia haje I'm a palace ame
Right.
she danso mame yo.
Mhm.
But what we did was copies of entry of judgment
Mhm.
wahanu wafe no ka pete germany ni ani am wafe press conference ni
Right. Mhm.
na ka pete ni me amena create awareness
Yeah.
ka innocent developers say ke ni biake
Mhm.
judgment wo yin ani na ni
Right.
ni ka maba na maba ni wo ka matashi
Mhm.
ni wo kwe gbenu no wa tun
Mhm.
ni ke payment plan kwa lo be no wa nuko wa ya me ni amo me na ijole na me yeje
Right.
ke nuko am na kan ba fine e ja ke ni ahabo order for possession ji ba ko anu approach mo
Yeah.
because te ka go structure e no ba sa ni mo ewo
Mhm.
ona me ni cho
Yeah.
ke mo enye ewo ba sa na shi mi mo ni court aye ne ke woni awo
Mhm.
ni onyo tashi be no wole bi no wa na no wo ke possession order ba
Yeah.
but the ocean mi
Yeah.
wo lock you take possession.
Mhm.
Well, thought we create awareness.
Okay.
Well, awareness create any many your jame.
Mhm.
I mean, like judgment you were in.
So it's not that you guys went around threatening people, but nyentani because that was the issue from the press conference. That was not right. Okay.
She no akere ko petition na ashi na mes one we ko no ka atwabo o ashi mashi mana no ko petition o many kashmo anye spon ji ama me no court judgment ni wo yin no am ba atwabo ake bo respond am ake ni na me na ni no ka me twabo asani bo onyo ka ma no kwale ake lela ake obi amena judgment bo kenye ba anye na me nya bo am tuipo no na ba yo ni ba ke wo ni wo kwa be no ba ala
right.
She naka be no ba ile she ake press conference na ha me 60 days mo ake no won bi ake judgment na me kan ni wale ani gbe ni atun aka court ha me wale
that is the next question ni minta o mabibu ake would you guys be this thing is in your favor? I'm a guy, me 60 days in your bad negotiate. Is that something you guys will be willing to sit down with them within the next 60 days? And if so, what would be some of the terms in your agree? Even though this judgment was in your favor, I don't know how that works, but that is what they said.
Yeah, okay. Man, saw you more call about press conference to you.
Mm-hmm.
I'm a chair. You want it was threatening.
Mm-hmm.
I can't work as you tomorrow. But no, no, but what touch work with.
Right.
Shakaba can have 60 days. After 60 days, a war.
Mm-hmm. Yeah, maybe I can go about no. Yeah.
About no war.
Mm-hmm.
No issue no your jacket. Because war in judgment.
Mm-hmm.
Ni book on judgment. On in your favor.
Right.
Judgment you on a tomorrow to be think about you or your plan on it.
Right.
Since there are nibi communico or you will back. About you not back in abo.
Mm-hmm.
If you can't turn back in abo pe. Kokwena you aje na je. Judgment. We call no shishi. Obanyo akote ni judgment. Ne egbla mi atwo.
Yeah.
Allo to be you no appeal.
Mm-hmm.
What no you no je akeshi. One near what fair press conference. She was fair about fair.
Right.
She no one was fair. Call back for judgment me. One I restrain Sempe manye kese kame che previous
yeah
workmen service assigns no effect money and cashier defendant pedi no ni I restrain
yeah
she many train a me no koye Sempe manchedi allo Sempe manye ni ame tone of tenancy can Sempe say
yeah
mofia mo no Sempe say ni to be na me say press conference na ni traje fi na me ka me Sempe say
yeah
court restrainer woka owe no ko no ani wo fe press conference ni woka hele ameshi ake yo mo na me yo ke amale yo mo jugba ni ame na me followers ya fe no ko na yin wo ka agbram get court in the issue of contempt ameka ka wa keshe ko le wo itunwa ya ke contempt yo ne is a criminal case one is a criminal criminal
yeah
because o ya gemini a grip bope mo wo baba mi
right
ni ame bana na bra me yomo se
right
ona ni onye yomo ni wo press conference no fe no ame na bra me yomo se
right
ke kole ame do me ya ajan ke ni na me yo na me to me ame can convince ame client say na me ke spoon ha ni awon ame na ke wo awon ame no ko fi mo no ko fi ni na me yo emo is scandalous
right
he's making mockery of the court
yeah anima biene o answer mo she miss mo no fail emphatically clear. You are not laying claims to any shipon near your sakaman ke damman. You are not.
Dabi.
Agbene no ni ma bi
claim.
Right.
Claims no get here. Damasaka
Bemi. Good. No ni miss money ma be next one ke channel yake from the press statement in kanye in habwe. I mean in man be they claim ake nye register shipon jinkome yang mete ke late bi okoshi ni no me sempe amame lands ni and ye ja no kwali ake nye register shipon jinkome yang mete ke late bi okoshi.
Oh, nika yomo ko meka me yo nle be na me no yomo nshi. Eja ke tumo wo shipon ni wo chon ni Nii Danso ke ha Nii Danso ni Kofi Akashi ke ha transport register 1980
okay
ni court ni 2131 1980 a register shpon ke ha Nii Danso Kofi Akashi ke ha Nii Danso 1950 and others the Nii Danso and others say am me convey ke ha Nii Danso in 1951 in 1952 I register deed registry he did registry a stamp district registry
right
ni 1980 na register school but since 1980 school ni after official search ni jeje you here since 1980 na register but je kumo years from 1980 to when no you is not almost 45 years san you was no connect registered in them for 45 years nini se ne ba nini ke na register ni small na ka bia me ni wo chon ni 1980 no me manjo ni adotobo. Ni adotobo ever to member of Lands Commission before.
Right.
Ni jebo kekeni. Benia tatakpeshi chwe say money bakwa tatakpeshi say ni papa mako no me leji man kra lo kian Sempe. De kwese kata be na to adotobo na adotobo ba. Na to do po ye mancha kata 2018 they train say na egbo. Eke danso ya court down. Ake danso ya register shpon. Eke danso ya court down. Ake danso along Ngleshi buku ya register shpon. Neke sanine to obini yuo 2009 ni wache Nii Danso na eku ete ni wala ke ya wo ni won wa kweso duba ni neke ni bi na tishi aja ke che twinse
Right.
Ro danso fe papa Ngleshi fe baba bo na ko pa wo mi na bon flom bo ni na me yuo ke ni ame cha bro miss make fe na me fe no go be mi
Right.
a bro miss spoon ni amo me register for so many years.
Right.
Ni ko te ni bi na ton what Lands Commission bana but ke Sempe register na noni wo no what you no jake ko ba kan judgment to bana ke 1970 court of appeal judgment na me na I'm a plot judgment
Yeah.
na me plot no ko free search na kan bia ni ona
Yeah.
ake judgment in favor of the Sempe to 1970 ona be ni yo na me free publication you know ni judge you so they brought all those documents to court no na ke si pelela ke si Sempe me na me o me I'm a tesegwe I'm a tese for almost 55 years because 1970 the court of appeal judgment no you don't rely on
Right.
to do their counter claims. Page 40 they just said it clearly.
Yeah.
They rely on the 1970 court of appeal judgment to do their counter claims. In our judgment, the Supreme Court
said no aside. Yeah, it said no aside. Yeah.
We restore 1963 akola judgment.
Judgment.
No did they ask use. No care over court. No fake claims. Ake spon bo no ni. The judgment is Supreme Court wo acha for no keba. But me that boy can ake judgment no yin etuni. No le no ni poten no do one oge club match ko kakachi ko match ko.
Right.
Boko wa bi ake si judgment na April 15th. Ken kwa na monyo get temamini.
Yeah.
Well, Nile ake judgment you are not okay with the judgment. Why don't you do appeal? What was serving with entry of judgment? What pete and share? You don't have to appeal because press conference cannot overturn the judgment.
Dabi.
Yes, a press conference cannot overturn the judgment. Ni no contrary to judgment is contempt.
Yeah.
And it's tantamount to prison. One woman to okay, you mo jena na you amekwe ni ameche kame bi kame nyeme na asafo acheme na mewole kame le nekule ama jigbeko no ye bia me press conference na me fi wo but like incite me na ma cause me allow me go contrary to the judgment nika ba na kan be mo wo baba
na kan
anima cha me na ma gbra me
anima bibo ene nyele claim to any amateur like Sempe Manche village need the freedom leun ebe clearly ni kan no be any nyeta wo ebe me but they said it in the press conference ake jeme leun enye bote mi jeme ni me ni yo jeme enye threaten am all of that any amateur le Sempe Manche village na ame afunu kuku ake freedom me jeme leun ebe na kan ni bi am
ebe nuku be to be ni chon yen ye Sempe me amele na me shkon yo aja ke dili ko ole oni loji no ni ke boko ka wompele oju no chon ni ye ni poten yo ko tele nche yu aga me na chon poten ye na me chon amedama aju sakama
right
so the court was only basing on the judgment any akwahwe yin na aton ake odama Sempe no sakama Sempe no freedom Sempe no but Sempe men nche na me ba court with their counter claim they could not describe because ka ofe claim pe but no ofe description of your land you what you share the land the court of counter claim the onus lies on you to be ni plenty fair no ni bo no asani you need to describe your land na anake ekolo spoke agency north of this south of this east of this south of this
right
Right, but now I go be freedom on no.
Mhm.
See, Oshpon enjoy all this, but you could not even describe your land.
Yeah.
Even though you turn up 2 strong witnesses,
Mhm.
2 secretary, can be the CP of
Mhm.
Sempe Stule. Many of them they could not describe Jenishpon, Sempe Shpon, yo.
Right.
This can be a Johnson Agbona. Judgment, they could not describe their land.
Right.
The judgment won't make about Dumosania now. Judgment I watch out for.
Mhm.
No, Nibia any negative court no judge no could potentially do. Dama ga sakama ni jeje yue is based on the macro concession inquiry.
Yeah.
Ni nwe ake jeme na dama ke sakama kwa Sempe no ni wani jeje ke o. Per 1961 ni ne macro concession. Ona even in their press conference they were even saying that judgment was delivered in 1960.
Yeah.
But that judgment was delivered in 1961.
Right.
So it means that men backward, they were not prepared. The they were not prepared. They have nothing.
Right.
I'm a main judgment na 1970. No, you know na ketwa ma. Na me ketwa me. Na me ani me ale ake 1970 any kashin. I 1990 Supreme Court judgment.
Yeah.
They watch out.
I
can
that's
be
right.
press conference put you know to can clean you. If you ake macro concession and no judgment no the yastic. No you know chon sakumo lo shpon.
Yeah.
Kaje no say judgment ko be.
Right.
You know can Yaudade crap.
Yeah.
My case, a consolidated case.
Yeah.
It's one back and the cash point is a sakumo.
Yeah.
It's surrounded by the sakumo lagoon. Anyway,
yeah.
No Supreme Court take High Court because Mago concession inquiry any Eduma Bosman. It deliver. It's High Court judgment.
Right.
Ni Yaudade crap case it out to Supreme Court. No, the Supreme Court judgment over a supersede any other judgment.
That's right.
You know, I now use a call at a judgment. As a yastic car, you have a quarter land.
That's right.
In Jamestown School. So, you know, you more is
right.
You walk up, you are a boy.
I mean, 1 second. Me add a few of my panel. Ofane keji okwo ni oye saniko no ba bi e boli oba gbe na bi ade no so ko e saniko no ba bi e ani male ko ni just text him hi to sane any chat say get sane number ani your screen there no keke ntwabo keke okay osane bi mo efe mini okay osane bi mo ba ani ma bibo in final question keke in hand over can panel e ka mo am sane na be ba bi ni ameke ba now ameke anybody need about receive any land ni more here keje Sempe ma de na can no is invalid me you know you are na can no
Kasanye no we na gba eja ke court ke bu ake school ni charge me papopora ni ke mi sango ni ke Sempe no ni court ke nya ke papopora ke mi sango no fe Danso mami yo. It is traceable to the Jamestown Alata too. Well, ke o ke bukwa ke sponsor police Sempe kan do mo asan wo ka ma ke sponsor na me kan ye ni be na me choje papopora ke mi sango no ni no mi amelia ke Sempe shupon ni ameka ameni me aba e ja ke court ka ma ke papopora ke mi sango no fe Danso ma shupon
right
she je Sempe no
and must start with Oshi because of Aileche expertise and again Jani be ne war. I would like to start with Aileche. Oh again.
Yeah.
Over anyone way obo liake ekulote in and out obo some portions of Nibi and in Candia for the past 30 or so minutes and watch and wig basani no ko ye no ba you alone sani ko ye no babi.
Otini okay, sorry. Animanga triboloy ke Nikwaloy. Agbene tafache nyeme fe ningmene ngre trane amba fata woy. Agbene huwe nliake dagu ke biana ke won tune ke no tumone wana majiache me ni alo chukuno etalalo ni babo otwi ojugban ni yake amembo otwi no maba amefe amedin omanye agbene huwe onyemi nuwe ningmene ngre trane afata woy ni alo oche ya fata wo ni egbela ni bi ami nke ha wo le ho madalesh ake febi ne ba egbela ni bi ami nke ha wo If you like see but Ngleshi no me Ngleshi along
Yeah, bule na ke jala tanomi. Nii Danso, secretary to Nii Danso ne.
secretary to Nii Danso.
Yeah.
But fine inja denta
Okay.
ko me insha
Daddy at
ntuna ntuna denta when my trouble ntuna magbele inya denta key into me one time. Me speak. Agaga otron ro je gan sa lo o tunu na again. No ntuna again. Ya denta ni om did it. Yo, but if you like say tomorrow you mean that we me in and out because me meeting school me. She na gba ko ni yo ni eba like si ke eba dansoma eba dansoma shipon hemo alo dansoma shipon shikamo in like say ekura ni court address like I issue me ne woni gbawe bi alomo wi ake shipon ekuma dansoma ni ke tafa che ohie be ta ke gbawe bi ni afe wolo abo alo gbawe bi ba ka si o ja oba me won na afe wolo abo o fa na ka no ke no ko ye yo mo ka cho woni wonu suduba
Eke uyo mo sanya pa. Ni
thank you
neke sanine wonye ni eye court. Ija ke noni wonaji bawe ame wocho nuko Amadu Wangara judgment. Ni Amadu Wangara ni bawe ame eche no enyo meneke enyemi ame kame ete court. Ni amena judgment no ame mpele wuku ichoyi. Ni mukome ejemi ne keshkun ha ne Amadu Wangara ni meneke eleji wuku icho na sene kan meneke jile. Ni court ibumukome ben ni ibumukome ben ni ame use ne ke judgment na me ke plot shipon kete ahun ekume poni wochon na ewu danso mai wo ke o conduct search una ake judgment in favor of ni ne gbawe kwate family 1963 wo na ke no ne ke ni ne me gbawe ke Ngleshi akukot ni win Ngleshi gbawe ke danso mai akukot no te vote gbawe ba plot danso ma shipon ngwena me ka me choje me gbawe otudo na be ko na choje gbawe otudo no noni wo fe ji ake ba ya sanu wo ka me a court wo ni ke bo wi oni ke si se pi enyu ete impendi e ja ke ame grantee se ko me na me ke shpon ji ha ame won ka ona wo sa me na no e ko me won ke wo court asi wo ke gbawe je je won wo ke le court e ja ke wo ke shpon ko ha precious real estate ni shpon na o ke ha me gbawe ne na emo na no ke ni na so ke precious estate court ni ask for injunction na refuse injunction edofu na gbene ya ni many ke shpo je ha amemini amameba see there is a judgment ni kashi ni 2018 ocho le Moro Yakubu versus Augustine Segu ni efia sewa akote ha na ka judgment ni ke shpo ni nje ko etatagu fa ke danso ma fa ci kote ha na le ake na raje gbawe shpo na ga shpo ni chon gbawe register moneke ha mo register shpo she kote kani aliake shpo na chon danso man and it's traceable to the Jamestown store we hold Lands Commission na for more registration title na ke ha ene me fita ehun no meji ekome ehun ni wo fe ni wo bon ne ke entry of judgment shipetemo wo fe public notice na ke bon shipetemo kenya anu ake ochie nu mami ne ba we fe press release ni amo ameke ni bi enu otun won mali se nunu otun je ake ba we e ka we akokot ni igbe ba kan da so much more won won ye mi pen ne chencho no ni eba ne ni sempe me ne pele one ne ga no awon ba pele na ga no wo yo mo fun ma wi
yo next mama bi no le ke shipon di next ade no yo ene ka kwa ni pambros ka tetogu eni wanyemi no pampankun ni lafa ema ipare se ye an ka abo tetogu ni ami ani na kan je alo ma ka Chinese bi ba ma China mall mi ni ko
yeah
yo weja yo no
oh okay
no la ka je gbe fe China mo yo je me fe ani gbawe ameno minini because ka o you suppose is and no about to jeng be aga fe even Makata Hill ame call jeng be fa gasin ame skon o fa na gbra mo min keton ke ha to ebolo ni anu na ke ni bi na mi odugba yawo o fa ni
Okay, nche. Beka wo ba ji shipu ke je Pambro se Ngleshi ni ke ha. Nje mene ke ha over 50 years ago, since 1966. Ngleshi ke ha. Na ke bon ngo efi mo. Wo ke gba wo ke le no ni o wa bia ke for over 50 years ago. Mi no e ba ko ni mene dan e ba claim aka le no ni. Wo you ake judgment plan judgment na me use na me ke plot to shkondi. It was fraudulent. Wo like a fraud evaluator no fiano. Ni court ya mo mene ni wo ke Sempe me court ni mene wona o ye kunu ni. Ene 10 years sani. Dan ni mene kunu ye chon no. Wo ka me court ji. Ni di gba we be no ko come kra e makati. Gba we be no ko come kra e ni gbe no chon fin kete tete go an kete. Ameke be ko ne wo ameke green agricultural farms. Ni di pine me court. Ni ame bia ke shkon ni pine ke no ni je pine no pa e fe counter claim. Ni Jamestown ba join. Na kan case na ye ni na gba we eluzu e ye for ake shkon le chon je le no ni pine ni di green agricultural farm. Le la ke Ngleshi shkon ni Ngleshi kin ale. O ke Ngleshi kin ale be pine be small le no ni bonje ole bo la ke pine e Oblogo ke teto. Wo na
yeah
kan je me fe no na fe ta to le ten gba we be no ko come je ni teto ogu manche Ngleshi se yo.
ese
Ona be ni chon teto ogu manche Ngleshi se yo. No gba we na ame yo je me ame be no ko come ye na kan akuche na mfe mi. Cha me gba na me fe plot here je. No ji no na me ke deceive o me. Wo na kan ni wo ye mi na chencho aba fo mi. Ni Ngleshi ba ko mama papa ni bu ye na kan
ama bi ene ke bo gbena China town na mo China mo na ma je me na me ke je me ha Chinese beer call it
Chinatown ama gba obi ga.
okay
Chito peni yo ye mo no yen bi aneke wa ice kon ko no fe official search. Mo ni gbe ni o na je leji mo ni mini. Ke wa na granto ye. Ni they are corporate entity. Onyo ogo na bu keka aka ma ke ni ebo no ni. No bia mi ni o ke mo ba court. No ba je money ni ye. Ni aba hold balance commission. Ne je na kan gbe fe ju gbe na ke o je na je fe je. Na kan bia mi but mo le ba na la ke currently le je granto.
gato
No ni ma wie ni.
o fa na yo o ra do ese yo that it
All right, thank you so much. Shout out to Mayema. Mayema, to your thing. Oh, you don't worry, Mayema. My job. Thank you so much. Truly appreciate you a whole lot. Nadoma. Yeah, over the empire again. Impa neke sanene egami we kukuku. Ndiake sane kone sumone bi ndiake meno kelen kwe.
Pabola se run baby.
That's right. That's right. Okay.
Ile ekole ke ba ibe ba kwelita.
Okay.
Because she kwen ya bi question ko no bi.
No, I see.
Ya bi ake no occupant ni yo jeme. Ke your neighbor le o mina ba fi aba assure me ja no mini gbenu ambachu ni ame so time ya ke ame hish bon na ama mutunye ku be yes ni ame settle no ti aba fi ame ti aba kumotun alo mi na ba fi no bi na ka question ni e answer
Eyin akobi ekole mo ba join wo bi anene check. So masumone sa e answer ko. Yeah.
Right okay you
Okay, be
okay
kama
sorry yeah that one who ma be work answer take then be second question fine
kama wie kun to be ni ton yen wie. Ni wa kote han wo iwale. Ni wo ke pon wo smuji ni judgment ne wo kete. No ni yo mi no ji ke wo yemi ko alo wo nyanyoko ni eye ne ke smonia. Onye o aka ko asule. No wo le bi ni tuma alo shi amayo han. No I believe I can no fin fit ani kote po han order for demolition.
wo be mo o ge ba tashi ake nyami ne le wo ake emini eshiponche ni won le lake won tenant bi anani ahon an lo mo ono na ba fe nu oji ka value shipon ngene ni ke bo yu ona ke one plot na value de balake kule 100 cities ahon le abanya ke sen ba nye kele yibo alo wo ko ba nye kele ba ko pe mo eminja won je na ke habo I'm no pay minja abanya fe payment plan de kan sha ke wo be o use money je tin alo no ji pa no ke pay na afe proper document abo ke you need wo do for regularization na afe ka gbene what e won ke abalake e ko ma ba di je mo ke ni bi ni sempe mene you say wo nu ame ke no le order for possession how well it is an executable order no ni executable order ni no le ke ba na kan wo ba ke bo ake be bomo ni oni bi ni alo shi anu ma ke tako no be ko wa no abo tako no tele ko no tele won be lo mo ni bi e shi an ni wo ke kado wa mun no to ake what process onye order to process it si no fi anu aye human face was that the no kan mene shi po kan she follow a de san no work ma wo ka de san yo apaye no mo ma bo nyon ka ma tashi wo no energy bejano to ni kan shi ni wo ba ya
Yo, oira don boni bi aneni bi e batron hel game yalo ga helishi na pa no ke abale ne kin ni nyemilishe judgment no sorry ke abale ke nyemilishe judgment no be wo hweji ake eko mefe mo aba eja ke be pie ke abale na kan ni anilishe no pe keke yenye so nye te ye me kume ba teshi ke ka me boi se ya keke ke toto mo ba e wo ame ba ka ke mene ba chon floor mi keke ana me ni mamo twie ko alo shikonji ko me ni ka she ame ba ho keke yenye te anonwe keke toto mo ba ke afi na ba shi o shweji nye ba momo nye he kome kweni noni kanye he ni amomo le fe ni eye mu kweni totomo ko akaba keke achi nyeta ye gbegbonyo no ake na me fia una ke amene na no na me fio agbene nwe nye kwa aga me first o ke chikoje ko meye game afi priority ni nye to ni tete tv ne wo agenda ko mi ne chikoje no ni yo aye platforms bi gama no ni abanya ke hwejeme na atwa adafia ke game fe ne fe klalo aka me baba shia na me ba he chikon ni wo se me ba tamia lo be kuku na me ba tamie nye ke priority aha amen first wo pa fight ene ashe ye gan biantone ateshi ojogba ntamobo ni taflache bo po ba fata wo ye man se bi e fe hi do eja ke moko man na ta no amede cha me ma ke amembaje ni noko ameshikoni ni cheme fight ha to be nye kete na kojua hanene wo fe nye meji wo fe wo shikoni wo bona fe ni gan ye hi jagame no bata gan ni development ke ni bi na ba gan ye hi ameno ameka ba ke gboke ba ni se na mo be ba wo ke ye man ke gan no ke ba ni se na mo ba e ba ka ye gan shikono ke gan ete hi no ba bi ake ke ya ne nye ke ba fo wo hi be fami o ba nyo ke cho ni tete no alo ada platform ko ni akle ke ba ni wele keke eye mu ha game
sanya pa man
o ba pa ni fight last question o fa ne te ibalete ni Ngleshi Alata ba kete English here ya ka ke Ngleshi Alata wo mi jo ake ke English mi le woni ake Alata epete he
ona ke ma ya se fiu
Yeah.
Be history han wo liake. Beni Ngleshi member. Alo woche kuju ani leji money the founder of English.
Yeah.
Nuchulon ni ameke brofo meji meni ameke chuni. Ni ama tuni keje Nigeria ni amemba. In the mail to be no liye be ko ni wa ship na use of transportation. But na member be so na ba pe ke di Jamestown. But be no ni ayo ja ke o mail ni je Alata ni ba. Mail ni je Alata ni ba. She many ba is a British company. Na me to African Trading Company. Na ma mo fort ke ni ne castle ke di. Well, nutuloy alo ni atwa artisans. Ni amame ke African Trading Company phone. Amame di many ni ama tuni contract konkro ye Nigeria. Na amame baga. Ni na amba na tuni amama fort ke ni bi ye kan Jamestown. Well, mail ni je Alata ni ba, mail ni je na Alata ni ba. Well, ba la ke ka aye akwa ma ga Alata biye. Ala many je Alata biye na ba. She Ngleshi ni fita here because of British. Into ake Ngleshi biye. Well, Ngleshi Alata biye. Ngleshi biye ni ameja Alata na me ba. Well, dini gbe ni ba ka de fe Ngleshi Alata, Ngleshi Alata, Ngleshi Alata. Doni.
No many tab mail no. Okay.
Mail na me je ani ne lake to benu woli mene ni ka po play ponje ku ba lake play ne je South Africa di ba. Well, ba no ka gene South Africa mene play ni je South Africa. Mene mail ni je Alata ni ba. Ni na bia mi ke mene fe ke ship ko alo plane ko nje manko ni ba I inform ye ne ba lande ake ship na no plane ne ke bi egbe ijo ba wo ale wo shona fe ake mail ko nje Alata ba wo be many ni je Alata bi ni na member company ni ship ni na ke mba British company na me company egbe African Trading Company wo ba la ke be Ngleshi Alata biye na meba. Ngleshi Alata biye na meba. Ona bi ni yo. Bo be ni baka Ngleshi Alata. Ngleshi Alata.
O be mail kama mi sisi be mail.
Be mail ni je, ye ni gbe ni mail je. No I use mail egbe keba.
Okay.
Ni ya mi kwale mi hu. Ye bia me ni ameba she Ghanaian. Ame ku amesa me ya don.
Oh, no be Alata bi ni your mail keba.
Thank you. Ona ni si je many yo je me je Nigeria bi. Si nutuloy ni to many chonyen we ama mo fort ke castle ke ni artisans no artisans ni yo mi ama tuni ye Nigeria ni amegbe na me na contract ye ogane no ame njeje me ameba me ba la ke be mail ni ja Alata ni ba mail ni ja Alata ni ba no jino ni afele Ngleshi Alata e ja ke company egbe is African Trading Company English British being ni many men ameke chuni indigenous na ameke chuni e wo na fele Ngleshi Alata
nkaba wa bi ya ke ni puzzle we han ya ke ma fiti she we nkaba wa bi dan ma be one question e da ke indigenous ni e atuni na memba na oni he woni sana wa megbe Alata na ameta mail ni kemba
ona ke ma boy yo mo mi ko won na kan bia mi Jamestown wo je British bi yo bi ni oye Usher Town na ye Jamestown ona bi ni chon Sempe me ka kuma je no ma fit asene men na me fit asene si baby bi ni yo Usher Town ni jikinkan no ana ma machine na me ba Jamestown no Ngleshi bi ni di British bi ni Jamestown bi ama me nutulo na me ke chun ni gbe me di je ni yo ama me di many Sempe ka kuma je bi ke fe ko me aka me na ke gbe me di jinji ni to nu o cho gbe Ngleshi mo ni dun ame yin di weche kojo weche kojo nika ache weche pe Barcelona ke ayo pran alo adania ona bi ni yo yeah but because of artisanship moko ye ni mason moko ye steel bender wo company here they come tu oni they come fan gbe ke ya sha me na gbe na me ba Ngleshi alo me ba Jamestown
Germany be na kan bia me Jamestown wa che Jamestown. She soko give na choje. No ama me buy ni ame buy Jamestown alo soko na me buy shi na me ma 40 tan. Ame shi ni septe pa je feel kombe. Na me fe Trinity ni balake be money here ame here ni giwe che kodue. I'm actually ake legi manche indigi se fe ame manche. Ke ha 3/4 se ni di Sempe akuma je ke Ngleshi. Ni ya balake be amekanye mi amekwame se don be balake be Ngleshi enye chalo many before make a tune ame ba fe permanent establishment. Yeah, what my name ni Jamestown. No ani be ka jadi abalaka ma yanko. So be e kan.
Alata bi o number fe permanent
Yes, I'm a fe permanent establishment. No me anwe me ya bi omo wo ya nyeme ku make Japan. Ona be ni cho. Me ku ja asante fanteme kagbene game bon Ngleshi nu wo na je one entity Sempe me je ku me yega I me ni je gamashi wani gbe na wo Ngleshi wana ke gbe different so ma didn't tan ni nyemi nu ku me ba you didn't tan be asnemen ona be ni cho no it is a constitute no ko tun menen wo United States of America man you are getting ye o Ghana man ni na ka ji be ni Ngleshi yo asante me je me oye ku me na to je bantama oya kwam ona oye fanteme oya kwapime akwamu me ye Sempe me asran me na ke from Jamestown
no be akegbe pete Ngleshi e
be keke na ke pete
e identify ake
yeah
what's neke koni ana li tomo bonike to bonike nu ganu mari ekwe ye nyon lo tende ka me fo
ekule boko me Kumasi ke fele ayi Kumasi ke ayi ke na kan be no
ajele neke o be no okay yo eshe oirado
eshe ogaleje over the man wo
yo ni jate table of mimba do manye ni jate you adon ha wo gbe na ne nche mimbo do manye
papa you am blawo nche
ni money in you ya eti ni akosia e papa di ni kwekuma ni egbo leji ni kwekuma bi kenkan je me why agenda eja ke Prince Ashaku Blue School yonko
okay
leji ni kwekuma bi sha ma mi je me fa mi pa egbo eti achola akosia ncha ite je gbese wo je anejewe at the same time atupa ni Ngleshi agene na neta le un ejemi na sofa ne te papa ba ya dare ampo aduma nku manche ni ato
okay
no inye ye ni Ngleshi le inye ye mi ojupan
magani
imi no ni inyu oji ake eni je ebo no mi wakaboko be Ngleshi wakaboko be no ni je ebo no ano ye ko teke ni ate Nii Danso leji moni bi ne ke ha anye ni de no akeje nye no oje papa ba tasi na ba akane ni mene ka ne ke akeje nye no mi ona dance eko ni sane mo fe mo ale boundaries ona ye sane mo ko cross okay am ko no mi akeje bo no mi je papa ba ko no ba ke ba mo ko lo ka mo lo da wuti se wo oje me wa bo je bo no mi o ke mo ko be mo ko ke mo ko be e ja ke chipo ni oje abachata de la suesi yeah la situation no tembo ko ya ko de me be o to bu chame ake ne ni batata ke bulu ji abi ni esa ni ko bulu Ngleshi ya Sempe no mi Sempe la on ba Ngleshi mi no sani mo femo awa ene yo UAP ingbena
tanyapa
ni dete ingbena
ayabache again
and check it busy
ebe busy feel ishe oshin ba mi mo ni wo muna bambam
if I na do ma Saje na call a friend na se du ko shodu ma.
Mhm.
Ala ko la ni e ko ni la hu ye no ko ni e ko ni nu. Alo yo mo ko ni e ko ni mo ko kele. Ora be ni o shine ko la ni no na call e gbe different ye etu ebi. Den anye ge no hu aba.
Mhm.
Ora be ni o shin ke a reconcile no fiano.
Mhm.
So to what you mean you are na ga ji on African Trading Company ye na kan bia mi amenye Africa popa no ni before me ni na use or medicine ke tune ke ma je no tubone ora be ni o shin.
Mhm.
No ke iba ko to su o yo so ala ta wen je me.
Mhm.
Ameno
Mhm.
or mi ameno agameje ni we che kodu e agalaga danke ba. Now the same will be another member. Amega another alata no go back. No what all show so la woni mi artisan le ba English yen no ena sika dugba le gba ka ojo go e o so ni ojo go like the first person na fu your ojo go no gbe ojo ni o so ni no ko nu agesi eni ba sika dugba won English no ana agesi ko kwe ogama sate mi yen kem ko na sika ye ogama sate mpe ni ba pa oh sayo so na ke no na yo la ga yo mo now
Mhm.
because of le he ni na ga yo mo ba gbe ye gan sayo o ni nani Yoruba nyoni efita meli na ba na oti I think I can see after you like my jenny be na fete no e wa to leader crab ke ha Ngleshi I want to agbene mancha ile bomba ni wacha kojo no ba botemi na abo mancha ile eje me o de mi he no ojogo kote man probi choko ojogo acho Ngleshi bi ago na for mancha me eje me ata Jojo ni kote wo jami wana ke se gbere tene o show ora be news he no no gbura mi fe ke chon fe na ka bi ni bala le kura ke na do me nu ji wo kura English the word is English ni avagorize you mo they are talk English alata o de mi ga me chebo awon de baba la ge sin bi na chole English ora no onye adoma ngebo bi ma je
Atama. So okay.
mo mbesi o believe your number eche o de mi sin mbesi no na ka ji be ni abale ha ora bi ni mo de to e ba je ma church mo trading center ora ni mo fia mo ba ora ta fa ta ja fante aba aja kwamu aba ora bi news no ba o aja sante aba o de mi si no se aje fe ro ko fe ko te se aje mi fe ta fa boy pi ni mo ne to na abu ahina de e ba to United Nation ye je me ona adenta na je ni unje atu reps kaje asene no mli jaba ora bi news ni mi de je diga bo yo mi na susu na to le dede ansa o e ka nyami ama wulu ama atu kaba no share mi na yo wala che ora tutu ko aye manche bia na aye manche si feze wala che di no yo share mi ni mi ini te ko chafla e ba to no kolo ya denta no mi as wala che mi je ni ora no to be de gbura mi na ka ji bi ni sika mo yo ha ora no
Egbela ni ele ko nu sise di no bio keke ona boni sanona le obviously be ko pete mankohi ye gan ni be ije wo certain ije no be no li wo ni be there should be a reason he wo na ke na ka be pete na ka no no wo tomo beni in bila ke o tomo beni ke ganu ke ye enyo ke tenshini afọ ade no li le ko ha example ake ka afọ ayi metin be ake ayi emene ayi mampon ayi neke ba afkai keke boni igbala mi no wo ehani na agbene no ni he woni inu no ni sisi ninu ni bi question
That's right.
ehani na
That's right. Inche, ovane, our final words ni one more oyi wala don wa ke okay wo ishe.
I'm a bit of Danny.
Ovane ke bamo.
Yeah, no more. Benin your jackashi. When I got quite judgment time, they can your bear come any beg judgment time. Maybe I tell I can bear the now. Oyoko Chuchu Jamestown. Suppose I told you Soko. Now, tell across Collier fan, Collegon fan, Soko song. Man, probably fan, Soko song. I can be. I'm like I told them fan. Then I'm about bed. When I get a night bed, fan. Dear, like any. They were spodian no tron biane what try ko zodiac you swag si e ba fata spodian no you ekoi what try ko Russia road and in the jengbe fitai
Zodiac Danso man.
that's so mami
Zodiac Danso man.
okay no zodiac me jeng bed jeng dugba na zodiac ba
Zodiac ka wo yu aba emisango no ona emisango no na yu emisango no me nunko money ba jeje kenkini Hausa do ni atole emis royal ile no ne aje mo na wo emisango
okay no biane ko tao jengbe poten je zodiac ni
da je Zodiac la be company be
no wona ga biane biane no jeno ni me cho no nke obura like no me ni man
wa na ga Zodiac je nche estate
na kan
kokwo du wa na ga Zodiac estate properties on your Danzoma estate
na
bo
kan
mene ni ko ocho be Danzoma se fiot mo akuto azanu na gba ko ni ga owu ya le fe easy abu ni mini wa nyo na je bo Zodiac gbe le yin la je bia ni Zodiac obinu oyo akụkọ foto we ka I still no che akụkọ foto mo fe mo le na akụkọ foto yo ona be ni cho even though akụkọ foto e ko ko e ni yo ka gbene ekumo po ko ba ke ya mekun o le ni mekun yo because I can use so ni ake mini ake fit mo landmark
okay
but no mele asani enyin she fe estate mi no ni Danzoma estate mi fe Danzoma estate mi
the
tunga jameji tutu bego ni wo jonkoblie tunga le Hausa ma ama settlement woko oshe ko to tunga mene alaka ke bo ya Hausa ma je street ni ama me manche je tunga manche ke chi yu ni ama me no ama fi ama school ka me no fi no je bo ko ke tunga le we Danso man si nini yoji estate ebole ma si estate da we ebole am waka mo ne ba ko Danso man dan to be no chetunga ne the moment they anya chetunga pe awanya directly ke ya ago bia ji na chetunga si tunga won no Danso man mi no doji tutu ko be ne wo atore jonko bie
okay agbere bene ba le ji age so mba gba ko ni sana wo ji eje me osofo dazi sana je le eje one time
evetumo ona onyoonyo akuchogo awon kemoko mbana akucho anya use ogbe even though je bo batoma sha use ko komo to ashimashi ko te komo to Mr. Minsa nla ko la Mr. Minsa won le Danso ma bole
ele mi danso
ko te komo to Mr. Minsa ko to Mr. Minsa aba tun bo na akucho but nke gbeji ni do me akehan le nya mini efe easy accessible kemoko to iku ne fe easy accessible de kanye ilaji
bebe ba le ji aba fada bi ele be aba chake osofo dazi ke ngba oje ni ama osipan ko to pon us na chake gbe agbena
All right.
Yeah.
Yeah.
I atama bi question ko bi ake ni tunga hu no ani chon ake tunga egbe denche tomo beni first question ni bi ni ajon le egbe denche tunga le hu egbe denche lo
tunga egbe jenje ji jonkobli ni jonkobli nwe Hausa gbe fi Ngleshi manche ni eke Hausa me ni tunga no ama me wuje me tunga
ni ame noni alo esisi no mo no na me chole tunga age most efia ni outside 23 yo wana eko atobe na acho nima ona be ni ton keni bi eni efo badan so ma
o fine como ni maneteni o que site wala
yeah
ni man no jemele po
yeah wo okay nima si mena ni ka boyu the moment na ba che nima pe wala ke si ausa meni yo je alo ni ma mena ni ka boyu o che tunga pe ona be ni ton alake o che ausa meni yo dan so ma
ke adabraka ke ekume no be boni ga ya here ni ga you fe nwe hengbele ba ame here wa be ji ekume to bi ni atama yue bi ane shi ye fo aka ke le gba we efi ake gbe ji ekume agbene sania revive me achaki ame enoni sania achaki ka eyin chaki mo ake gbe apete existing one
no asane wo feji esane wo fe I think ake no ne ba yin fe moji ake some of the streets can be ni yo ne ka kuche na mi fe ka wote roads and highways ne I think a local government ministry me yo in charge of naming some of these streets sane wo fe collectively assembly and wo fe sure ake and ba name some of these streets na fe ke gama bay ona boninchon no over the time ni ebanye checking some of these things I think that is where any is any work ni ebawa wa de nche briefly yeah ofani rap mole app ya wo ko ni wo gbe na Oshin listen Dabi I mean by fa esani what Oshin hold on Oshin hold on esani work be show na we need to bring it to a close what 4 hours 35 minutes sani work back
1 second no over na tunga be sani wonu shishi ora be news because ya eba heshi do sana nu no ni ka che tunga sana anu shishi ona ga jonkobli no cho ne mukole nji mukole ni the meaning of aka wa che jonkobli ata tunga sana wonu abia me aga na kan yomo na mi tunga mi denshi ora ya ka gbe ka mo wonche because shipon ni dia kwa
waka manche ni oje baba ni wo bile nyani yeah he cannot give you that explanation you know be this is not the conversation
sisi no wo manche ba wi okay don't go bring you to nga manche wo ga ba
na kai
sisi no mo
ni ana ni ko ya bia mi ni kwa ba
sisi no mo
ni ka gbena ni baba se ni bi mi nu ni sane mi bi sane ni ya gbene ni ya ni ni ba ni bi mi sane ko no mo ingi do boya
ima ovane family quickly esani work pa ovane trial bamba ni where ovane
one question per ma bia ke iyo si ake Danso man fe street ni yo jeme Sempe bi ni ke wo Sempe bi agbe ni yo no te balete ni abale na kan
kwale ke wa ma wi judgment ni eni wona ke bi ane no dino ni o ba dmo no ke chake gbe eja ke to mo be ni tro ni yin am 1970 court of appeal judgment na me plot report no me ko conduct search ye jeme ona ke judgment in favor of Sempe 2 ni no am use na me do mo no na me ke claim portion of Danso man compensation but ye land commission records no meneni what the court ni no ana le ake ne ke 1970 judgment I watch out from since 1990 ni one court in executing our judgment no you know na kwa gie 1970 judgment ye all no fiona ni court Danso man lands aka gie no ni supreme court judgment ni no a plot in favor of Ngleshi Alata stool no ke a fair plot egbe na ne ke gbeji neni no na fin wo ba dum no na ke ji fin geje me onu eye wo agina omo fin asana odum no ko no dani o ka fi no ko nto obeni wo fin wole ke judgment ko aha ni judgment epu eyin ye bia mi na wo pa cha kwa fun alo agbra ko mi na kan judgment still is valid wo ngene ni mo dromo na true judgment ne affirm no ni Supreme Court wi aka kulache atuni ni common boundary say iwo gbogbo eye o si pon mi se ke le spoon ke e o le gbe conclude judgment ne explain fe wo SDD ni judgment plan ne no wo ba plot pe ni ke judge ne no na ka na du mo ka je fe
Yo, oira don be oya kapa kama no e. Boy, say like concern. Yo, oira don.
Well, don't
All right, inche ovane our final words ni woke banagbe mo.
Nche, madani finishi, maja opla manu unshi, madabo unshi ake bona be ni oke blood nke yumo ne mi fito. Noni mo yue no jake, ekun ke gbekoshi. Judgment aha mo ne, ni judgment amole befia mo ba fi, mo ba yi fo, mo ba yi be. Ne twa ke mo ko yi fo, be twa ke be gbele ni. Noni yo mi no ji. Many for alo many Sempe se ka kumaji na meke ha ame ani maba Nii Danso e bele gidigidi no ni potenerete kote ke ya kote ba balake ni echeshi alo echebu ya ahun ngene na wole manje egbe fe go titre weti wo ke ni modromo na ni efe ba hwe yin ke nyeme ba eyin e ka ba tashi ni nyeme afa nyeme ni nyanyo afa nyanyo e ja ke be ni wo ya court na efe Sempe me ka kuma je nka me pe wo mo no gba asani wo nanga no ke mene ni ameke many ameke shpon ha na mamo share na me ba wo ba kwe ni no ni sa ni ake mene e kan ni nyema le nyeme ni chaleche ni bialeche no wo yo mo no ji ame mani me aba ni me ame ba na ba to tenancy ni je mo e kuma na me jui ni kuma ya shi kote ame bra yo mo ise e ja keke wo ke ya mo ko ba nye tai ku ne kwa ya ame ba bra yo mo se na me abe ni ma ba ni wo ya wo yin ni ejola ba ni Danso ma be na le Danso me che aka ula ma de kan shi no ne twa no manya ba
Yeah, inche oyi wala don wa de nche dum a job wake okobe ni okewo eba na sande gba ngene impanele min danye fenshi min panye fa nye ma twa moko ngene. Unfortunately I cannot call anybody today wo obasa obaba bi ko ni oba fi another show o fa ne wa de nche if you want to have a discussion with wanyemi manyama provide an opportunity ma but unfortunately nye magbele line say ni moko atwa so min panye fa wa isani work was show abanagbe okanleje
Meantime, normal. Meantime, glad discuss local. Very important.
Over you.
No, maybe about your economy.
manya ki amuche
Okay, meantime is very, very important. Thank you, local.
Right.
All right.
No. So thank you guys so much. My catching your very work on walk over over during the course of the weekend in your fair Manchester story konin chombo boli nibi na atana ni adama la chenegme. There was another document kuni a creating atana create co-kinship in the kwekuda afe ni phone and people are trying to afe no feel no na about afe ni boli what is mean the co-kinship na can document when nka ba chombo wo oyi wala don wa de nche oba pe bye bye
ite wa don
Hi.